Good morning, everybody. We're going to call to order this November the 14th, 2013 meeting of the Tennessee Alarm Systems Contractors Board. We want to welcome our visitors and so forth that we have here today. Ms. Vest, will you please call the roll?
Keith Harvey.
Here.
Vivian Hickson.
Here.
Karen Jones.
Here.
Mackenzie Roberts.
Here.
Stephen Tucker. Let the record show Stephen Tucker's not present, but you do have a quorum. Thank you, Madam
Okay.
Chair.
Has the board had an opportunity to review the agenda for today's meeting, and if so, a motion to adopt?
Make a motion to adopt today's agenda as presented.
Second.
Okay, we have a motion by Mr. Harvey, a second by Mr. Roberts to adopt the agenda as presented. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. And then also, through electronic mail, we received the minutes from the September the 19th, 2013 board meeting. Has the board had an opportunity to review and if so, approve those minutes as presented?
Make a motion to approve the minutes as they have been presented.
Second.
We have a motion by Mr. Harvey, a second by Ms. Ms. Jones, to approve the minutes as presented. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Is our first guest here?
Yes.
Good morning.
Assistant
Good morning,
Commissioner
Chairman,
Giannini.
board members. How are you all?
Good morning.
We're well.
Good. Glad you made it here safe. I'm Bill Giannini. I'm the Assistant Commissioner for Regulatory Boards. And this is Kimberly Whaley, and it would take too long to go into what all she is. So I will just say that she's my right hand. One of the things the administration wants to do on an ongoing basis is to come to you annually and report on your board finances, to report what we're doing with your money, how much money you're ask questions about that. And we just got our budget closed back, so that's why we're here today. I hope you all have a copy of your
iPads. Okay.
like this.
Exhibit A.
You've got
Yes.
Okay. And I'm going to run through it fairly quickly. At any point, if you want to stop and ask questions about anything, you certainly can. I'm going to start at the top. You can see fiscal year in the right-hand column, fiscal year 12 and 13. Your expenditures for regular salaries and wages were $171,669, which was very comparable to the previous year. If you drop down the total expenditures, including longevity and benefits, was $263,413, which was actually a little bit less than the year before. Your travel costs were $10,963, which were significantly lower than the previous year. Those are board member travel to meetings and then travel that staff might have had to do over the course of the year. I won't go through line item by line item on your other expenditures. The total at the bottom is $160,589. That is again a decrease from and total expenditures of $424,001. If you drop down to, this is the part you all are probably most interested in, is your licensing revenue. If you look over in the right-hand column, is $689,680. You're down quite a bit from the previous year, and also the year before that. We believe that is because in fiscal years 10, 11, and 11 and 12, there were some large companies buying other large companies that resulted in a pretty significant increase. Look at fiscal year 9, 10, it's very similar to the previous year. So it's kind of flattened out back to what we consider to be normal. And if you drop down, you'll see net revenue, $707,660. That left your fiscal year balance at $95,100, and with your reserve balance at $654,677. I'm sorry, I always do that. $749,777 total. That was your previous year was the $654. 9,616 licenses. Registered agents. I'll get the lingo right here in a minute. 2010, you had 5,737. 2011, you had 6,590. 2012, you had 6,996.
I don't have any. Do y'all have any room?
No.
Okay, no question.
As I said, we want to start doing this every year. Come before, and certainly anytime during the year, you're welcome to contact us and ask anything that you want. You have a really, really good administrative staff. They do a great job watching your money.
Yes, and we appreciate them greatly for that and all the other stuff they do for us.
And they are one of the reasons that you continue to operate so successfully. I want to really quickly tell you about a few things that we're doing. We are buying a new licensing system that will be used division-wide to replace the system that we call RBS, which we've had since 1993 when Ned McWhirter was governor. And we are long overdue. Cody's group has been very critical to us in our development and needs assessment with the vendor that is doing that for us. And so we hope by the end of next year that we will be using a new system. Also have been part of an initiative that the governor's office has called Customer Focused Government. And it is basically an effort to improve the customer service experience for anybody doing business with the state of Tennessee, whether it be internally or externally. We are almost completed our training. We've done with the assistance of Ms. Whaley and several others in my office, have given the training to about 120 staff members, and they've been very enthusiastic about it. And we're already seeing, I think, an improvement and a consciousness about customer service. As you all know, if you need an alarm license in the state of Tennessee, you don't have an alternative. It's not like Kroger and Publix, or if Kroger makes you mad. So we think that and the governor certainly thinks that it's incumbent on us to go that extra mile because of that. We have a responsibility to make sure that we're providing the best, most efficient customer service that we can and using your licensing revenue as efficiently as we can. So, any questions? Well, we appreciate you all, and like I said, feel free to contact me anytime. Thank Director Vest, and we appreciate you.
Thank you.
Thank you.
Thank you.
Madam Chair, let the record show that Steve Tucker is present.
Okay, thank you.
Yeah, we're gonna come off that.
Next on our agenda is the legal report by Mr. Josh Kilgore.
Apologize, I'm still dealing with a cold or sinus thing here. My legal report for November 14th, 2013. Go ahead and jump right into it. First matter is case number 2013-016901. Complaint alleges that respondent, designated qualifying agent, failed to timely submit one termination notice pursuant to Alarm Rule 90-01-.069K. Respondent states this was an oversight that he noticed after searching the company's employees on the state website. No prior disciplinary history was found against this respondent. My recommendation is authorize formal and send a consent order with civil penalty in the amount of $50.
Make a motion, we concur with council.
I second.
Okay, we have a motion by Ms. Jones and a second by Mr. Tucker to accept council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2013-016841. Complaint alleges that respondent designated qualifying agent failed to timely submit one termination notice pursuant to Alarm Roll 90-01-.069K. Vice President of Respondent QA's company states that respondent originally listed was not the DQA at the time, and the responsible signing DQA thought that he had sent the termination notice in timely, but he had no paperwork evidencing this. My recommendation is authorize formal and send a consent order with a civil penalty in the amount of $50 to Respondent 2, who was the DQA at the time, and close as to the now acting DQA, who would be Respondent 1.
Motion to concur with council.
I second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2013-014871. Complaint alleges that respondent, Alarm Systems Contracting Company, failed to timely submit an application for one employee. The employee in question was hired on or about July 15th, 2008, but application for registration of said employee was not received in the board office until January 30th, 2013. Respondent DQA on behalf of the company states that he had previously been told that the employee's application had been submitted and was in a pending status with the Alarm Board office. The DQA was first told this in August of 2009 when he assumed the DQA position. There's no evidence that would show that the employee registration application was received in the board office prior to January 2013. Therefore, my recommendation is to authorize formal and send a consent order with civil penalty in the amount of $3,000, which is $50 times 60 months for failing to timely register an employee.
Motion to concur with council recommendation.
Second.
We have a motion by Mr. Harvey, a second by Mr. Tucker to concur with the council's recommendation. All in favor, voice by saying aye. Aye. All opposed? Motion carries.
Case number 2013-015571. Complaint was established alleging that respondent company failed to timely register one employee within the 30 working day time period required by law. In response to the complaint, respondent states that employee in question only performed alarm installations in Mississippi, not in Tennessee, during his time with respondent, and therefore did not require registration with the board. After investigation and further inquiry into the matter, there was no evidence to suggest employee in question ever performed any work requiring registration in Tennessee. Therefore, my recommendation is to close.
Make a motion to concur with the recommendation of council.
I'll second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to concur with the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-017901, 2, and 3. Complaint was established when 47 termination notices were received in the board office on August 28, 2013, all of which were past the 30-day time period allowed by law. The respondents, all designated qualifying agents for the same company at one time, previously or currently, stated that the errors were discovered while cleaning out the company's system and reported upon the discovery. Due to the length and time from some of the terminations, the complaint was established against prior DQAs, as they are at one time in charge of reporting the terminations. The current DQA has been disciplined for the same violation previously. Upon reviewing the termination dates for each individual, it was apparent that only 17 were done under the current DQA, while 3 were done under the previous interim DQA, and the older remaining 27 were done under the now DQA, who is now expired. My recommendation, therefore, is to authorize formal and send a consent order with a civil penalty in the amount of $1,700 to the current DQA. This is the second offense, which would be $100 times 17. Also authorize formal and send consent order with civil penalty in the amount of $150 to the prior interim DQA. First offense, 50 times 3. And to close as to the final now expired DQA for the remaining late termination notices.
I make a motion we concur with the recommendation of council.
Second.
We have a motion by Mr. Roberts, a second by Mr. Harvey to concur with the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-016081. Complaint alleges respondent, properly licensed alarm systems contractor company, improperly engaged in CCTV installation. Respondent admits that it does not hold certification in CCTV. However, further states that the main contract was for a burglar system installation. The CCTV installation consisted of one small system and would appear minor and incidental to the burglar alarm install. Pursuant to the Alarm Act and rules, TCA 6232-314 and Rule 90-01-.0313 respectively, it would appear that there is no violation, as licensed alarm contractors are allowed to lawfully bid and install systems outside of their classification if the job is minor or incidental to the main installation in a classification under which they hold a valid certification. Therefore, my recommendation is to close.
Madam Chairman.
Yes, sir.
Josh, I would disagree with your recommendation here.
Yep.
The incidental installation was really, to give you an example, the incidental installation was originally intended to allow someone to install a smoke detector while they were installing a burglar alarm system, and that was what we considered incidental. And it was also be a part of the burglar alarm installation. You put a smoke detector in with a burglar alarm, so they didn't. CCTV installation is quite outside of the installation of a burglar alarm system, and so I would not agree with this recommendation.
Um,
I don't recall right offhand what our penalty for that would be. Perhaps you could advise
I
us
believe
on that.
the guidelines are if they're acting outside of their certification, first offense would be normally $500 for the first violation for acting outside of their certification.
So with that understanding, I would make a recommendation that we authorize a that we go ahead and authorize a formal hearing. We offer a consent order for in the amount of $500.
Does it, I'm just asking, does it specify what can be incidental or supplemental? Smoke, CCTV, fire, or just in our laws? I'm just wondering if they're gonna come
See-
back and say, hey, the laws say it doesn't specify
See-
what's incidental.
CCTV isn't controlled by a burglar alarm.
Yeah.
It would have to be something being a part of it.
No, a lot of your DSC panels have got, I've never
Way
used
that
but
the,
they have
and I apologize, I'm not trying to
camera.
interrupt, but
Mhm.
the way that the law is stated, 6232-314, Part D, an alarm systems contractor may bid on a contract requiring work in some classification or classifications other than the
Outside.
one or ones in which the alarm system contractor is licensed, if and only if the work is incidental or supplemental to the performance of the work in which the alarm systems contractor is licensed to engage. And the corresponding rule, I don't know if I have that.
The laws and rules are on my iPad.
Yeah.
You need it.
Let me pull it up.
Certified activity, right?
Says here in the rule, a certified alarm systems contractor possessing a classification to engage in one type of alarm system activity, e.g. fire or burglar, may engage in installations outside of the designated classification without obtaining an additional classification, provided that such work is minor, incidental, and/or supplemental to the performance of the work in the classification possessed by the certified alarm systems contractor. Submission of bids outside of an alarm systems contractor certified classification shall not be deemed minor, incidental, and/or supplemental to the performance of work in the classification possessed by the certified alarm systems contractor. The way that I read that was that if he submitted solely on a job that was solely CCTV, then that would not be considered minor or incidental. However, it looks like in this case, it was a burglar alarm installed that had one small camera, which I read to be minor and incidental.
Okay, so go ahead.
Go ahead, Mr. Tucker.
And I guess I read that is if you weren't classified in a category, you could bid a job, but the person who did the work had to be classified in that. Saying that anybody could bid on a job as long as the contractor that did the work had to be certified in that category. But you're saying now that the way this law reads is that if I do a burglar alarm and put in 2 cameras, those are incidental.
Well, that's just the way that I read it, because it says, the rule says may engage in installations outside of the designated classification without obtaining an additional classification, provided that such work is minor. But
Let me offer some additional comment. We use the term, as I recall, supplemental and incidental. Incidental would imply that it was part of the incident of installing the burglar alarm system, and this particular instance may fall within that category. Supplemental would bring the understanding that the installation of the camera was a part of or supplementary to the burglar alarm installation. Now, recognize that some burglar alarm installations, especially with your newer technologies, do have a closed-circuit TV camera as a part and integrated into that burglar alarm system. Now, if that's the case here, where there was a camera that was installed that works in conjunction with the burglar alarm system, then I would agree that it would be supplemental or incidental. If on the other hand he was installing a burglar alarm and then also installed a couple of TV cameras and a recorder, for example, then I would not consider incidental to the burglar alarm system nor supplemental to it. So I guess we really don't have quite enough information. Do you have any more information on what work was actually done?
I believe in the file.
You see where I'm headed. If he installed a camera that was part of the burglar alarm system, then conceivably it would be incidental or supplemental. If it was just happened to be done at the same time, he installed a $99 burglar alarm system and installed a $3,000 closed circuit TV system, then I don't think it would be minor, incidental, nor supplemental. Again, I kind of go back to the original intent was to allow someone, if they were installing a burglar alarm system, to put a smoke detector, a couple of smoke detectors in with the burglar alarm system, which is pretty well a standard practice, and not require them to maintain a fire alarm the fire alarm classification.
Looks like in their response here, and I'm quoting, we were contracted to install a burglar system on the grounds that we also install a small CCTV system that the contractor provided for us.
That would sound like the CCTV system was a separate system from the burglar alarm system. So-
In that case, I think
That's not supplemental.
Well, perhaps we just need to pass this until you can get more information to find out specifically what components, if it was a separate CCTV system, or if it was just, as they say, supplemental, a couple of cameras in with the alarm system before we make a decision on this. But I think you need to make them explain specifically what the install included.
if that's the board's wishes.
I had made a motion, but I don't think it was seconded. I had made a motion to, we authorize a formal hearing, and, yeah, I don't
I'd
think
like
it
to
was.
see a copy of the bid, right?
Well, did they want a camera system, and did they say, hey, if you'll put me in a small alarm system, you'll put my camera system in for
Right.
me? That'd be different.
But I don't think we can make
No.
as to what was done and what action to be taken.
Would Josh, would you read a couple of sentences there to us. Could you repeat those without a problem?
No, that's fine.
To me, they sounded like separate systems.
Yeah, because it used the word
Well,
CCTV system.
And I kind of stopped a little bit short. He says, we were contracted to install a burglar system on the grounds that we also install a small CCTV system that the contractor provided for us. The next sentence is, the burglar job was contingent on us also installing the CCTV, which we installed both.
That
Got you.
specifically means those are two separate systems. The
right.
intent wasn't just to do the burglar alarm. They're going outside of their classification to do CCTV.
I agree based on that, knowledge we didn't have 30 seconds ago, but I agree, it does sound like there were two separate systems installed by this person.
Somebody can second.
I'll second.
We have a motion by Mr. Tucker. Let's start over. We have a motion by Mr. Roberts, a second by Mr. Tucker, to authorize a formal and a consent order for $500 for out-of-category activity, correct? All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Josh, I do hope that you kind of understand where
Worms, didn't
what the decision was based on, so that, in the future,
Right.
the question may come up again.
Mhm.
So.
No, I understand that, and thank you for clarifying that on the record. Next case is 2013-016891. Complaint was opened when the board office received an anonymous complaint alleging that respondent was working 2 employees in positions requiring registration without properly registering the employees with the board. In response, respondent states that all alarm transfer applications were submitted timely regarding the 2 original employees in question, and further, respondent submitted 3 additional transfer applications. Out of the total of 5 transfer applications, 4 were received outside the 30-day period allowed by law. All employee transfer notices were received on 9/16 of 13. The hire dates listed on the original 2 employees were 4/15/13 and 5/13, respectively. The other 2 notices list hire dates of 6/20/13 and 8/5/13. The total months worked by employees without registration totals approximately 13 months. Therefore, authorize formal and send a consent order with a civil penalty in the amount of $3,900. This is their second offense and times 13 months unregistered.
Madam Chairman, I make a motion, we concur with the recommendation of our council.
I second.
Okay, we have a motion by Mr. Roberts and a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-016811. Complaint alleges that respondent, designated qualifying agent, failed to timely submit 2 termination notices In response, respondent admitted the failure and in addition stated 17 additional individuals needed termination notices. However, only 9 notices were actually filed with the response. 6 of the additional termination notices were submitted past the 30-day time period allowed by law. The other 3 were for persons who were never properly registered. And the remaining 8 names for which no termination notices were filed were either never properly registered or the board had received prior notice of their termination. Recommendation is to authorize formal and send a consent order with a civil penalty in the amount of $400 to respondent DQA, which is $50 times 8 late termination notices total. And also recommend that we establish a complaint against respondent company for failing to register 4 individuals. I think I stated 3 in the paragraph, but there was actually 4 individuals that were not registered.
Gosh, this one's kind of convoluted here.
Yes, sir. I agree. I have triple checked and ensured that that is the correct number of late terminations after going through the entire list of 17 that he had submitted. He kind of submitted all of them in one lump sum, and some of them were late and some of them weren't, and some of them had never been registered in RBS.
Madam Chairman, I make a motion we concur with the recommendation of our council.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Josh, would it be appropriate when you establish the additional complaint for the 4 unregistered individuals to make some reference back to this particular complaint so that we can see that it all kind of ties together? Would you feel that appropriate?
I believe I can do that, yes, sir.
I think it would probably help us better understand when when the other complaint comes forward that might make a little more sense to us. Thank you.
Next case is 2013-012061. Complaint was established by former owner, partner of respondent, alleging that his former partner, DQA of respondent company, a licensed alarm systems contractor, failed to properly register employees requiring registration with the board. Complainant states that he, as 50% owner, relied on respondent DQA to ensure compliance with the Alarm Act and rules. Complainant alleges several people requiring registration were never properly registered by respondent. Upon extensive investigation and review of sworn statements, it appears that respondent alarm systems contractor company failed to properly register 4 employees that appear to have required such. Respondent also admits that they helped him on some installation jobs. Respondent's defense is that they were merely contractors and were not employed by his company. However, the Alarm Act makes no distinction between contract employees and regular employees and also makes joint ventures between unlicensed people and entities illegal. Further, it appears respondent company engaged in CCTV work on at least one occasion without proper certification to do so. Also, I think it's important to note many of the allegations in this complaint stem from a partnership and a business venture gone bad and is not within the board's authority to impose discipline. This was a very convoluted matter. Recommendation is to authorize formal against respondent company and send a consent order with a civil penalty in the amount of $900 for failing to properly register 4 employees and for engaging in CCTV work requiring certification, which respondent did not have. So that amounts to $500 for the unlicensed activity and $100 per unregistered employee.
Company had complaints in the past?
I don't believe so, no, sir.
Is this an active, ongoing company, or is this one that's kind of collapsed in on itself, or do you have any understanding of that?
From my understanding, originally it was dissolved and has since become active again, but the partnership has collapsed.
Partnership fell apart?
I
with
believe that the DQA, yes, sir, I believe that the DQA referred to here is going to be continuing the respondent company.
So the complainant has gone away, but the respondent is running another company after this partnership.
Respondent is going to continue to operate, yes.
Madam Chairman, I make a motion that we concur with the recommendation of our council here.
Okay, we have a motion by Mr. Roberts,
Second.
second by Mr. Harvey to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Next case is related, 2013-016-101, 2, 3, 4, and 5. This complaint was established to fully flesh out and investigate all issues as related to the above referenced complaint, as there were many entities owned and operated by co-owner complainant in that previous complaint I just read. Upon initial review of the above matters, it appeared that there may be further unlicensed activity indicated by respondent company. Our investigation produced a sworn affidavit from respondent QA in the previous complaint stating that CCTV Worked was a, quote, joint venture between respondent 2 and 5 in this matter, and in it he admitted that it involved himself. Respondent 2 and 5 deny any part in the CCTV job. After thorough investigation, no evidence was obtained to show unlicensed activity by any of the other respondents listed in this complaint. Therefore, my recommendation is to send a letter of warning to respondent 2 and 5 in this matter regarding improperly entering into a joint venture where both parties require licensure under the Alarm Act for the CCTV work, and close as to all other respondents.
So this is related back to the previous complaint?
Yes, ma'am. These are companies that are owned by the complainant in that matter against his former partner. And our investigator did a thorough job, and only evidence that the respondents in this complaint really that I could find is the sworn affidavit from the respondent in the previous matter that we just discussed, stating that he did the CCTV job with these entities, but there's no other evidence that was able to be obtained. So I think a letter of warning in this case is the best course of action.
Motion to concur with council's recommendation.
Second?
Okay, we have a motion by Mr. Harvey and a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-015-041 and 2. Anonymous complaint was received in the board office alleging that respondent company had been engaging in an alarm system installation without first being properly licensed with the board. Respondent owner admitted to operating without proper licensure in writing. She further stated that she was unaware of licensing requirements and that she would immediately cease all operation and dissolve the company in August 2013. Respondent CEO also admits she failed to register at least one of her employees. He has only recently made application to be a registered employee for a properly licensed alarm contractor. Respondent's website states they have been operating since 1998. anonymous complainant also indicated another unregistered individual as working or being affiliated with the respondent. However, no evidence can be found linking the name given to engaging in alarm system installation, and no response was received from that individual. I believe that it was returned undeliverable. But my recommendation as to respondent company is to authorize formal and send a consent order with a civil penalty in the amount of $5,000, and close as to the alleged employee or respondent for lack of probable cause for discipline.
Tell us what kind of business this company is involved in?
It was alarm system installation, generally.
Madam Chairman, I make a motion we concur with the recommendation of council.
A second.
We have a motion by Mr. Roberts, a second by Mr. Tucker to concur with the council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-016151 and 2. Complaint filed by customers alleges that respondent company and QA charged their account prior to the alarm system being installed and refused or failed to respond after several attempts were made to contact respondent to dispute the charges and canceled the contract. Complainants allege they filed a fraud alert on their credit card and a police report due to this incident. Respondent states that the only reason he charged the card prior to the installation was because complainant asked him to charge it early on Friday pending a Saturday installation due to the fact that they would not have enough money in their account to cover the charge on Monday. Respondent states that this is not a normal practice at his company. This matter seems like a contractual dispute, and complainants have filed a police report regarding fraudulent credit card charges, which I believe are best handled by the police department. Respondent stated that he is willing to refund charges. My recommendation is issue letter of warning regarding misconduct under 6232-319, Part 9. And that's to both of the respondents in this matter, the QA and the company.
Motion we concur with council.
Okay, we have a motion by Ms.
Second.
Jones and a second by Mr. Tucker to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-018241. Anonymous complaint alleged that respondent improperly bid on a large job requiring licensure with the alarm board prior to being properly licensed. Respondent admits that they bid on said job, but they have not yet been awarded the job. Respondent also states that they have not performed any security work or alarm installations that require licensure with the board. Respondent is currently attempting to become properly licensed. The only portion of the bid that seems to require licensure is the CCTV portion, to which respondent states they were attempting to get into compliance prior to performing that portion of the job. Despite respondent's efforts, the fact is they improperly bid on a job requiring alarm certification prior to obtaining licensure. Therefore, my recommendation is authorize formal and send consent order with a civil penalty in the amount of $1,000.
Yeah, I think I need to recuse myself from this one.
I believe that's the next one.
Is it?
Yes, sir.
I make a motion to concur with council.
A second.
We have a motion by Ms. Jones and a second by Mr. Tucker to concur with our council's recommendation in this matter. All in favor, voice by
Madam
saying
Chairman, a
yes.
little discussion here. Let me ask a couple of questions on this one. As I would understand it, now, of course, I'm assuming that that the company has not been licensed. The company that bid on job has not been licensed. They have made application for license.
Sure.
They bid on the job presumably was awarded. We
don't
weren't
know.
really given that information, but the fact that they bid on the job, is that a violation of our statute?
Can't bid on a job
Can't
without
bid,
being.
advertise.
without being
You
licensed.
want us to the
Yeah.
need, quantity,
Solicit,
or
knock on a
quality.
door, nothing, until you get a license.
Well, it would seem to me that, for example, a general contractor, and I'm taking a hypothetical case, could bid on a job that included some CCTV work and then subcontract that work to a licensed professional to do the work. This particular bid could fall in the same category. They could, even though they've made application, they could turn around and subcontract this work to a licensed company, and that was the reason I'm asking, is this a violation of our statute?
I'm reading from 6232-303, 2. Alarm systems contractor means any person, firm, association, or corporation that sells or attempts to sell. And it goes on with the rest of it. Is considered an alarm contractor. As long as we had a bid or someone else had a bid from a company that was unlicensed.
They're talking about a large job, and I don't know whether the large job was a lot of other stuff in addition to closed circuit television, or it was a large CCTV job. I guess I'd like a little bit of clarification to better understand the circumstances here.
I still think it's the same.
Did they bid on it? But they bid on it.
Right. I mean, I don't.
Then that means you can't do that.
That's within our jurisdiction.
I'm not necessarily opposed to the motion, but I'd like to have a little bit better understanding.
Say that they are an 11-year-old technology company specializing in networking. They install wired and wireless networks and cabling infrastructure. Says that they decided to add IP-based CCTV to their offerings.
So then I'm drawing the conclusion that this was a large CCTV job.
Looks like they're applying for 2 classifications, CCTV and burglary. If I could talk. Burglary.
So they bid it.
But the way it's presented would lead me to the conclusion that it's a large job, that a portion of it is CCTV. In other words, they could be installing a internet system in a school, for example, which would be a substantial project.
Like they say here, there are approximately 40 video cameras in the project that could be considered security, but they state they are not burglary related.
That's CCTV.
Like they have a website advertising security products.
Okay, that's,
I think-
I think you've answered my question then, and I think we'd be ready to go ahead and vote.
Okay, we have a motion and a second to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries. Number 14, I think.
Case number 2013-019-791. Complaint alleged that respondent won a bid on a job that required licensure through the board without first obtaining any. Respondent admits that it did in fact bid and win the job without first obtaining licensure. Respondent states that it had an exclusion under the old law, which it filed in 2005. The exclusion expired when the rule changed in 2009. Respondent only holds a contractor's license with a ED classification, and under the new law effective August 9th, 2009, the only contractor's licenses eligible are those with a MC, HVAC, and also electrical contractor, which is E and EB only. My recommendation is to authorize formal and send consent order with a civil penalty in the amount of $1,000.
Madam Chairman, I make a motion to concur with the recommendation of council.
I second.
I believe Mr. Harvey is recusing himself.
We have a motion by Mr. Roberts, a second by Mr. Tucker to concur with our council's recommendation, with Mr. Harvey recusing himself in this matter. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Number 2013-018981. Complaint was established when it was discovered respondent did not display its alarm system's contractor certification number on its correspondence pursuant to TCA 6232-316D. Respondent admits it recently got new letterhead stock from its corporate office and did not notice the omission. Respondent stated and provided evidence that it has corrected the error and has discontinued the previous letterhead. My recommendation is to issue a letter of warning regarding displaying company certification number on all future correspondence.
Madam Chairman, I make a motion we concur with the recommendation of council.
I'll second.
Okay, we have a motion by Mr. Roberts and a second by Mr. Tucker to concur with our council's recommendation. All in favor, voice by saying aye.
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 All opposed, motion carries.
Case number 2013-018691. Complaint was established alleging that respondent, who does not hold an alarm contracting license, submitted a bid to provide a CCTV camera security system to a Tennessee county school system. In response, respondent states that it is merely acting as a, quote, consultant to an established, properly licensed alarm contractor. TCA 6232-304K states, no person shall advise anyone as to the need, quantity, or quality of alarm systems and sell the systems unless certified, licensed, or registered under this part. Further, the bid was titled in respondent's name only, and the school board awarded the contract to respondent only, as evidenced in a copy of the unofficial minutes submitted to the alarm board office. Therefore, my recommendation is to authorize formal and send a consent order with a civil penalty in the amount of $1,000.
Make a motion to concur with council.
I second.
We have a motion by Ms. Jones and a second by Mr. Tucker to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2013-016821. Complaint was established when board office received one notice of termination past the time period allowed by statute. The termination notice in question indicated date of termination as August 2012. The notice was received in the board office on January 16th, 2013. My recommendation is to authorize formal and send a consent order in the amount of $50.
Make a motion and concur with council.
Okay, we have a motion by Mr. Tucker, a second by Mr. Harvey to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Case number 2013-018971. Complaint was established when 5 transfer notices were received approximately 5 months past the 30-day time frame allowed by law. Respondent DQA stated in response that the company made this oversight when it had just been forced to move office locations on short notice after a foreclosure action was taken by the bank on their previous building. Respondent has been licensed since 1993 with no disciplinary history, and this matter was self-reported. Therefore, my recommendation is to issue a letter of warning. I think that there's some mitigating circumstances here that the board may consider.
This was self-reported as well, right? I make a motion and concur with council.
Second.
We We have a motion by Mr. Tucker, a second by Mr. Roberts to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
Aye. All opposed? Motion carries.
Case number 2013-019-051 and 2. Complaint was opened when board staff learned that respondent may have done CCTV camera work without first obtaining proper certification through the board. Some of the information was obtained as a result of respondent submitting a QA application wherein he stated he had installed CCTV and IP camera systems. It appears that much of the work respondent referred to as performed in Alabama, where they apparently do not require a license or certification. However, respondent also admits to performing at least one CCTV installation job in Tennessee prior to obtaining licensure. The board staff also received information that he installed cameras at County 911 Center. Respondent states he immediately started the application process upon learning that he needed a license to perform such work. My recommendation is to authorize formal and send a consent order to respondent company with a civil penalty in the amount of $500 for engaging in unlicensed activity, and issue a letter of warning to respondent QA regarding engaging in such activity.
500 on this one and 1,000 on the previous. Is there a reason for that?
Sorry?
Out of 500 on this one and 1,000 on the previous, is there a reason?
Generally, I believe first violations for the company is 500. However, on the ones that I recommended 1,000 on, they seem to be more significant jobs. That was really the basis for that decision.
Now, and I'm pretty dumb, I gotta ask a question. 911 center, is that government owned? Because we did have a case where somebody did some work for, that was federal? Okay, thank you.
I think their contract system has an exclusion.
Illusion.
It would.
This is a local.
Federal installation. Madam Chairman, I make a motion, we concur with the recommendation of council.
I second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Tucker to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-019-521. Complaint was established when respondent failed to display their certification number on correspondence to the board. Respondent states that they have contacted their graphics team and have instructed them to make unique letterhead for the state of Tennessee so that this will not occur in the future. Our recommendation is to issue a letter of warning.
Aren't all of our letterheads supposed to have our number on it instead of just for the state of Tennessee? You might want to tell them that. They're not just supposed to have special letterhead for the state. All their correspondence is supposed to have their number
I think
on
they
it, is
mean
not.
for all correspondence that they will be sending out in
To
Tennessee. I
anybody.
think they operate in many states.
Madam Chairman, I make a motion, we concur with the recommendation of council.
Second.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
Case number 2013-019-551. Complaint was established when board staff learned respondent alarm contractor company apparently failed to timely register one employee, as evidenced by employee's recently submitted registered employee application. Respondent states that employee in question was hired in January 2012 when he was advised to fill out state application. Respondent states employee failed to complete the application process due to health problems. Employee was then rehired by respondent in March 2012, but again failed to submit the required documents in a timely manner. Employee was then rehired in May 2012 when respondent states he finally complied with the application requirements, but failed to show up for jobs and was terminated before his application was submitted. My recommendation is to issue a letter of warning regarding timely submitting employee applications.
Josh, do you have any indication whether this might be a large company or a small company or something in between? Just, do you have any indication of that?
I don't know, sir.
Okay. I was just
It's a small one.
trying to gain a little insight.
It's a small one, I believe.
Sounds like they
Never
hired him
you
and
never
fired
get
him and hired
terminated.
him and
Right.
fired him and hired him and fired him and then finally
You
applied
can't
him.
terminate somebody who's not.
Or he worked here all that time and just told you he done all that.
Exactly.
That's what I
He's-
figured.
So if I don't have any evidence that he worked past the 30 days each time, it's kind of,
And that's what they said, so we're gonna,
well,
don't
That's
have
where
any
it's
evidence
paper.
to the
We don't.
contrary.
So he is no longer with that company
I don't
as of today?
I don't think so.
I mean,
If he didn't show up
as
for,
of today, he's not correct. All right.
he might be next week.
Now, tomorrow might be a different
That's
story.
correct. It's not a Saturday.
Madam Chairman, I make a motion, we concur with the recommendation of our council.
I'll second.
Okay, we have a motion by Mr. Roberts, a second by Mr. Tucker to concur with council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Mr. Kilgore, do you have anything else for us today? Says,
Update is on the
Update
agenda.
on the
Proposed rules update?
rules are still making their way through the chain. Honestly, I don't know what step they are on right now because it's gone above me, but as soon as I hear anything, I'll let y'all know.
Still in the pipeline, correct?
Mhm.
Thank you very much.
Thanks.
Madam Chair, may
Take
I
a
ask
break.
that we take a small break?
Recess for 15 minutes. On our agenda is the administrative report. Ms. Vest, are you ready for your part?
Yes, thank you. If you would, turn to, on your iPads, you would, it's going to be Exhibit C. It is your open complaint report, and as of today, on the report, you have 41 complaints, but I believe 21 were presented this morning, so that's going to leave us a. We did have a formal schedule for tomorrow that got canceled, but I do have already got a notification from our litigator that we've got some that's scheduled for next year. If you turn to Exhibit D, you're gonna find the disciplinary report. So as I get mine to. If you look at that first one, you have September, it was $1,000 for a civil penalty. You can see on there. And now, if you look at the second page of that, you will see that we do put the student loans, actually what we're doing is putting suspensions on. Ended whomever, for child support or for student loans. That is part of the disciplinary reports now. Over to your October disciplinary report for the alarm board. If my addition is correct, it's $14,100. And of course, these alarm, whether they be qualifying agents or registered employees.
This
Their
is something
license
new
has
that-
been suspended. Well, it's not new. We've had this all along, but now we're being told it's to be put on the disciplinary report.
That's what I mean, this part's
Public
new, this
record.
addition is new to our report. Thank you.
That, for the student loans here, or even for child support, the individuals are notified by the different agencies, and then I'll get notified. I put them in a suspended status. They get a letter that says that they are suspended. Of course, the company gets the letter as well. And then whenever I get notification that they are current with either the student loan or child support, I take them out of suspension, and they get another letter, so everything's okay. Sometimes it happens quicker than I can even get the letters out. I get the notification and I get that out on the website that they are suspended, I can get the. You see what we had on that one. And of course, if you do have any questions. Quickly, but we know what they are, and I'm just. All right, we're going to go to Exhibit E, which is your monthly reports for September and October. I want you to notice on September, the very first one is dealing with the exam contracts. They said first available examination date was October the 24th. I have some information for you. Governor's office yet. Of course, Mr. Tucker does continue to serve until reappointed. I had some information I thought maybe you might be interested in on the exams. As of 10/24, 13 people passed and 3 failed. And as of today, looked on the computer through December, there's 9 more individuals. Do their exams, and Beth and I were talking about that yesterday with PSI. We'll be able to be pulling off all different type of statistics for you.
I could pull those off this morning on the computer. It took me about 5 minutes. And we've never been able to do that, so that's a good thing.
Yeah, we're pleased
Plus,
with
if
that.
somebody calls me and says they're scheduled, I can actually verify it and tell them what time and location they're scheduled for.
Of course, they're supposed to already know that, but they do call. Over it'd be September and October there, I was told you. Well, October's gonna be the same thing, it just states on there that, for Mr. Tucker again. Giannini, the assistant commissioner, and then this is whenever Josh and I get.
In a year, maybe they don't want me.
I noticed one of your other boards has 3 members with expired terms.
Quite a few.
Yeah. We're actually 4.
That's okay. Yes, there are. We, not to make light of that, I have been in. We had a meeting with representatives from the Hill, from the governor's office, concerning an appointment. Not mistaken, this board, you have to be a qualifying agent or the public member. Hey, if you would, we'll go to F. Exhibit F. What do if you take a few minutes just to look at this, this is a gentleman who wants us to, wants you to waive the exam. His license is expired on 8/31/11. That was 2 years ago as of August. He's just outside of that 2-year little bracket that we've been telling people if you've taken the exam within the 2 years from your expiration date, you don't have to take the exam again. We'll let you. This is what I was just saying. That's what you have done in the past, and this is what the policy is for the private investigators. If you've taken the exam and it's been within 2 years of your expiration date, they don't require you to take the exam over again. But as I tried to explain, there's nothing in your statute that says this, there's nothing in your rules, and of course, we don't have any policies. So this is just something new I wanted to bring to your attention. Is something that we want to take in consideration, something that we might want to put into a rule. Well, right now, we'd have to put it into a policy. He was saying, I've already taken it, and if you look through here, you see where he did pass the exams. You'll see the exam scores that he did quite well on his exams. He has to reapply, but he doesn't want to take the exams.
Let me understand now. If I understand correctly, his license expired 2 years ago.
8/31/11.
He's making reapplication, but he doesn't want to retake the exam.
Yes.
And you're saying that we don't have anything in our statutes that says we have a certain time period? I thought there was something in there.
You've generally used 2 years in the past, but we don't have anything in writing that says
Anything
that.
in writing that says that. That's strictly up to the board, however you want to proceed that.
The reason I asked, I remember, I wasn't on the board, but I remember checking into one, and maybe it was 90 days that he didn't reapply, and someone had turned him in, and he found out that he had like 2 weeks left where he could reapply and not have to take the test, and did. So that's not in the rules anymore.
Not like where you're.
Maybe he had
discussing it.
taken the exam and never been issued
Yeah.
a
Yeah,
license.
he
That's
had
a
a
whole
QA.
different thing.
Yeah.
He was a QA for,
And a lot of the people that were grandfathered, if they come back and reapply, they have to
They
take
have
the
to take
exams because they've never taken them. We don't have any provisions for that either, so.
That's something
grandfathered.
that you think we do need to address at some point?
I kind of have a special problem with the CCTV because I know the CCTV industry has changed and the exam has changed dramatically since this gentleman probably took the exam at some point in the past.
CCTV exam, he made an 86 on it in 09. But
Well,
again,
the industry has changed a bit.
I've got
intervening
copies of
years.
his licenses from other states. He's still got valid licenses in like 4 other states. I mean, it's
Including
not like,
CCTV?
yeah, well, they don't always specialize, but he just didn't have a license here for a while. He made a 86 on the CCTV exam. He also took the monitoring exam and made a 90. He's not reapplied in monitoring, just Bergen CCTV.
And I just wanted to bring that to your
Got a
attention,
license in
you know, if
Florida,
he didn't
which is
have the
tough.
exam, probably wouldn't even discussed it.
Right.
But the exam is in place.
Well, at the
It's over
time he
2
asked for
years.
this, we didn't have it up and running or
No, but
had,
it is now.
so.
But, yes, I think it might be something we want to take into consideration. Maybe I can put it on the agenda for the next meeting. We'll have a little bit more time to discuss it, get more in-depth.
Is this for
in it
registered
tonight.
employee or QA?
No, he's a QA. Employees don't have to take an exam.
Alabama wants you to be NICEC. You have to have a NICEC level 2 to. Probably knows the industry. He's not a. He's got license in Florida.
Company, again, he's in North Carolina, and the company he's applied with is based out of North Carolina. He's not even a Tennessee resident, but.
Madam Chairman, I make a motion that we not grant a waiver in this instance in that would require him to, let me back it up. I make a motion that we do not issue a waiver so that this gentleman would have to retake the examinations in light of the time frame that's outlined here, that he would have to retake the examination in order to become licensed as a QA in Tennessee. I'm not sure I stated that clearly.
You made a motion to deny his waiver.
I understood what he said. I'll second
Deny
the
his
motion.
request for a waiver.
Okay, we have a motion by Mr. Roberts, a second by Ms. Jones to deny this gentleman's request for a waiver in exams for burglar alarm and CCTV. All in favor, voice by saying aye.
Aye.
All opposed? His request for a waiver is denied.
Okay, I have a question, please. This is what I was talking about, and correct me and explain to me what this means. In 62, 32, 313, J, no qualifying agent shall be qualified to receive a renewal license. The agent has been in default in complying with this part for a period of 3 months.
Right, that's a renewal. It has nothing to do with this. This man's license expired for over 2 years ago.
But after 3 months, it would have expired.
Yes, it would have expired,
And he
correct.
would have to go through the
have to
reapplication
reapply.
and take the test.
Normally he would, but that's one of those I'd bring back to you and say, it's been, because the renewal cycle's for 2 years.
It says he shall make a new application as in the case of the issuance of the original license. That means you gotta start all over if you let it lapse over 90 days.
Right.
That's what I was thinking about.
Different. His
Okay.
license completely expired. He does not have the right to renew. He
All right.
had to
This,
be-
this is just, what we're talking about here is strictly a question of the examination. He's making reapplication and all.
That's
Just-
what I thought
just-
that meant. If you reapply, you gotta go through the whole thing all over again.
And that's what we voted he
Testing all.
does. We did not give him a waiver.
Great. So if that's okay, I'll put it on the agenda for our next meeting. Perhaps we can discuss.
Time
You're
frame.
trying to get a time frame, so we'll have something in
Right.
writing. That's okay with our attorney. Well, I think that's going to include what I have. We do have appearances, but they are scheduled at 11 o'clock.
Are any of you out in the audience? Do you have,
If they're here, we'll go.
do any of you have,
Want to have them come up and sign in? Okay, y'all come on up here to sign in if you're ready.
Who is this, Beth?
This would be Exhibit H, Mr. Morrison and Mr. Claunch.
Going to be Exhibit H, if you want to turn to your. That's what I was going to do since he was already here, but.
He's not on the
You have Exhibit H, this is Mr. Morrison, if I pronounced that correctly. If you look through there, the first thing you're gonna see is the letter for the appearance. Then a letter for Mr. Morrison to appear. The third item is gonna be the denial letter that we sent out on 9/23 of 13. The next items will be your TBI and FBI report, the written explanation, and the documents are at the back. Gentlemen, would just give the board a few minutes to review your first time they've seen it. Ready for Mr. Morrison to come up?
I believe so.
Have a seat here. If you- Both of you are just fine. If you Yeah, have a seat right there if you like. Be more comfortable than just standing at that podium. But please do speak into the microphones.
I have one question, I think that may not be an issue for the other board. We have a sheet in here, and on the iPad, it's 3 of 3 in his packet. And it's showing General Sessions Case Summary, State of Tennessee versus Morrison. And it's got several court dates listed, the last being 4/18/2003, criminal bond docket trial. Then we've got jail docket felony. Do we have charges that correspond, or is this all? Sue Evans as the judge on about 6 different dates.
Pages, and I went in there and went, okay, so you got page, don't count the front pages, page 1, page 2, page 3 is the
Very
letter.
last page in the electronic file.
Okay.
It's a short page.
Are you asking me, has he been to trial? Is that the question? What is your
Oh, there's a
question?
docket listed for him for a felony charge on 2/22/13.
Person? Are you familiar with that?
Not a felony charge on 222 of 13. I can tell you what all of those trials were regarding was an indigency motion that was presented by the public defender. I'm drawing a blank on his name right now. But
This is Michelle Claire Bottoms is the public defender.
she wasn't the one that was actually there representing me. It was it's a strange name. Actually, I might still have it in my phone. Jared Mellencamp.
It just shows, that's what I'm trying, that's what we're kind of, or I am anyway. It's got State of Tennessee versus Morrison, so I don't think it's other defendants in this, but it does show on February the 22nd, 2013, in the court, it's the jail docket for a felony, and then it shows in March a misdemeanor, then in May a criminal bond. So you haven't been charged, there it is up on the board.
Oh, I'm sorry, it's not supposed to be on the board. Sorry, it won't come off.
I have no response as to why it's written.
Haven't been arrested since the public drunk.
No, ma'am, that was it. All of that was actually regarding that and the indigency motion that Jared filed on my behalf regarding the fines on that.
On this section here, the complaint, it's the affidavit, I believe, for Alabama.
Yes, ma'am.
It's got a lot of different, I've lost the page here. It appears that Walmart, or whoever, I think it was Walmart where you purchased that,
Yes, ma'am.
tracks the dates and the amounts
Yes,
of
ma'am.
these ingredients that you purchased, and once you reached the legal limit, went over that legal limit, that's when they initiated criminal action against you.
To my knowledge, at the time, it was actually the police department that actually requested all of the information from any of the local pharmacies and
I mean,
compiled it all
Walmart
together.
keeps a
'Cause
list of the,
all of the pharmacies at that time were keeping separate lists. I wasn't aware of it at the time. Now it's all one big list, so no matter where you go, they know how many you bought. But
Okay, I
at the
didn't
time, it
know.
wasn't.
your statement to the board today is, you've never bought any of these substances for the purpose of anything other than for personal use, not for,
Absolutely not. No, ma'am, I haven't. I've taken this stuff since I was 10 years old. I have never had any involvement with any sort of illegal drug.
Mr. Tucker, make sure you're speaking into the mic, please.
I know I'm. I'm just thinking on how I want to phrase this. I'm sorry.
Were you head of security for the Nashville Convention Center for a long time?
Yes, ma'am, 2 years. Municipal auditorium.
Mr. Morrison, let me ask you a question, just for my, kind of my own information. I noticed a couple of the purchases there, either at CVS or Walmart, was for 1.5 grams. What does 1.5 grams constitute? I mean, is it a tablet, a pill,
It's a tablet. It's a tablet.
a whole handful of tablets, just one or two? I don't have a conception.
I believe 1.5 grams was a box of 30. I think.
That's the reason I asked.
I'm pretty sure it's a box of
Some of the
30.
purchase was for 0.5 gram, some were up to 1.5 grams.
If it was up to 1.5 grams, then a 1.5 gram box would probably be a 60 count box of Broncaid.
What?
Broncaid and Primatene are the two products. They're the same item. One is stronger than the other, and it's more expensive, I believe. But other than that, it's the same stuff. It's kind of like Motrin and Advil. Either one of them work. It just one's pricier.
States are just so close together. You would use a 30 count.
No,
every
not
3-4
necessarily.
days.
If I found myself in a situation where I was using something regularly, and I don't remember the specifics about this instance because I didn't think anything about it when I did it, and I didn't start thinking about it till after all this happened. But essentially, if I have to have something at work, and I don't have it with me, I'll go buy some, and then I'll put it in my lunch bag, and then at the end of the day, I'll take my lunch bag home. I'll empty out the lunch bag, I'll clean out the lunch bag, I'll refill it the next morning, I'll go to work, and then realize I don't have it. Still, so I'll buy more. Right now, I have 5 bottles of liquid bandage sitting on my bathroom counter because I tend to be a little bit absent-minded in that way, and that's the only thing I can think of as to why some of those dates were so close together.
Because you bought 2 purchases one day and then one again the very next day.
The only thing I can do is make an educated guess, knowing me, about what would have happened there. And it's not uncommon for me to leave stuff at home or leave it at work or leave it in somebody's car. Especially if it's medicine that I'm taking regularly like I was taking it in Alabama.
Or would you introduce yourself to the board, please?
Yes, ma'am. My name's Tom Claunch with Southeastern Sound. I'm the qualifying agent.
Is there anything you want to speak to the board about on behalf of Mr. Morrison?
Well, yes, ma'am. I just wanted to say that while he's been with Southeastern Sound, he's been very dependable, very organized, very conscientious, seems to do quality work, and I think he'd probably be a good investment going forward if you guys see fit. And I don't have any knowledge of his prior, activity or whatever. All I know is the time that I've known him and seen the type person he is and the quality of work he does.
How long has he worked for you?
Since early June, I believe.
Of this year?
Yes, ma'am. And we filed for the application as soon as possible, and this has kind of been an ongoing process. So,
Mr. Morrison, I guess my question would be, and I'm trying to figure out how to ask this, but what do you use this for?
Initially, when the doctor prescribed it through my mom, it was for straight asthma attacks. I couldn't use an inhaler.
That's what I wanted to ask you. Okay.
So if you made these same purchases, amounts and frequencies in Tennessee, it would not triggered an alarm, correct?
No, ma'am, correct.
We're only in Alabama for how long?
I was there for 6 months, I believe. It was supposed to be 5 originally. I was there just to work the Walmart remodel, and they offered me a support manager job at the end of that, and I was looking at staying longer when all this happened, and then I decided not to.
Okay, well, based on that statement and the previous statement, why was it that just for this 30-day period, you seemed to be so forgetful out of all of the time you were down there? You were there for 6 months, but there was just a 30-day window that you just forgot your medicine.
No, ma'am. It's
No?
the 30 days are the only thing that's listed on that. That's what they took out the warrants for, was for their most.
We're just looking at it, if 1.5 grams, like Mr. McKenzie asked, is about 30 tablets, since we don't know, from a period of 3/29 to 4/30, you had 145 tablets. That's probably what threw the red flag, I imagine.
But only during that period of time. No other time did you make these substantial purchases.
That's, like I said, the only thing that's shown on that paperwork is the 30-day period they took out the warrants for. Because I was taking it pretty much around the clock the entire 6 months I was there.
But you needed it since you was a child, though. You said.
Yes, ma'am. It was worse when I was there because my father's current wife has a cat, and I was living with them.
I'm taking it at 10 years old. You had an inhaler. You weren't taking
No,
straight
sir.
Ephedrine.
I couldn't take inhalers. Inhaler for me was a lot like, I would guess, sucking off of a cigarette back then. Extreme nausea, coughing violently. The doctor had my mother cut Primatene tablets in half at the beginning and give me half of Primatene instead of an inhaler.
Madam Chairman, I make a motion we grant this application.
Okay, we have a motion by Mr. Roberts to grant this employee registration application. Do we have a second?
Second.
And a second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations. Don't disappoint us.
Thank you very much. Appreciate it.
Thank you all.
Had some new members come in that need to sign in.
Oh, yes.
Please.
Somebody's called tough.
It appears that Mr. Evans is not here. He would be of course, he would have been the first one we'd have talked to. So who is signing in? Is this Mr. Tolson? Tolson?
Jason Tellison.
Okay,
Yes.
good. All three of you sign in.
Aye.
Yes, ma'am. I wonder if you want to go ahead and be reviewing your iPad, please.
While the board is reviewing that, I would just like to read this for the record. This applicant, Jason Tollison, is appearing before you today to demonstrate that he possesses good moral character in compliance with Tennessee Code annotated 6232-312E2. Mr. Tollison was convicted in 2003 of 2 felonies: conspiracy to manufacture or distribute satellite signal theft devices, and structuring transactions to avoid reporting requirements. And considering these convictions, as well as Mr. Tollison's presentation, the board must make a determination as to whether or not Mr. Tollison has demonstrated that he is of good moral character. Should the board determine that he is not of good moral character, the board may deny his application for failing to meet the requirements set forth in the Alarm Act under Tennessee Code annotated 6232-312E2. However, should the board determine that Mr. Tollison is of good moral character, then it appears that he has met all requirements for the issuance of alarm employee registration.
And we've not seen part of it before, though.
New application for you to review.
Okay, thank you.
I take it that it's QA. Okay. No, as far as the people who are visiting with him.
Would you introduce yourselves, please? That's what the board's
Yeah,
asking.
my name is Danny Tollison. I am one of the owners of Guardian Systems, and Jason's actually my brother, but has worked for us quite some time, or did work for us.
And I'm Dan Jarnigan. I'm the operations manager for Guardian Systems.
Our designated QA couldn't be here. He's in training in Connecticut, and we had a short notice, about a 5-day window before we were notified to be able to meet before the board.
What's your first name?
Danny.
Tucker gets back, we can proceed. Unless you,
Tucker's rejoined us, so does the board have questions for Mr. Tollison or any of his party today?
I'd like to hear what Mr. Tollison has to say concerning the charges and such that we have before us.
Happy to. Specifically, this was over 10. Actually, the business that I owned and operated was.
Up so that, or they're at the lectern, one or the other.
So roughly, the business that I owned was from 2000 to 2001. A little late in 2001 when it, no. So roughly, I was in business for a year and a half, manufacturing electronics. So I was manufacturing a small circuit board that people use to interface their direct smart card and read and write their own smart card. Which, you know, if anybody with any technical background, we probably know how that took place. Just so happened I was a hobbyist and started manufacturing them, and I sold a couple to friends, and it turned into a business. And when it turned into a business, I realized that it turned into a real business. I mean, at one point I had probably 20 employees and was manufacturing several thousand units a day, had 401k set up for my employees, was paying all my taxes, whole 9 yards, so I was not hiding. I was not running from it at all. But at one point towards the end of that, I specifically manufactured a device because you could read and write any smart card in the world with my devices. But towards the end of it, where I got in trouble was when I specifically manufactured one to read and write DirecTV's newest card. And that was where the law got broken. And I regretfully made that decision. But it was, I don't like to say that it was for a greater good, but the reason I made that decision was because I had a certain expectation to provide for all of my employees. And the profit margins had gone to a point where we couldn't make any money in the business unless we changed. So when we changed, we broke the law. I did. That was my sole responsibility. And blame and the punishment for that and paid my price. Now, granted, that was, you see, the conviction was in 2003. It actually took them nearly 2 years to indict me. So when it actually took place was 2001. I had it to go back and do over again, I would not do it the same way. I feel horrible for everything that it happened and the way it all went down, and for the people that got harmed in the process. Can't be judged for our mistakes for our entire lives, can we? I mean, I made a mistake. You know, it's not, there's nothing else in my criminal history that you can see there in the last 10 years since then. You know, it's that I made that one mistake, you know, and everything else has been above reproach, I like to think. You know, and I've got a couple of letters of reference here that I don't know if you see that in the packet or not, one from our state representative and one from a town council member and a gentleman that I serve on the board with for a couple of nonprofits. You know, so they're people that knew me before, during, and after this. So if they're willing to give me a letter of reference stating that I am of good moral character and they realize the mistakes that I've made and they still trust and believe in me, I would hope that I could convince you to also do the same, not knowing me, instead of just reading the 10 to 12 page document that's in front of you that dates back over 10 years. I mean, none of those charges are anything regarding drug use or drug issues or felony assault or anything like that that's stated inside the Alarm Contractors Board statutes. So I feel like I meet the legal requirements regarding the criminal side of things. And I think the only way that I'm being denied, or at least the letters that I've been receiving, is that I'm being denied based on poor moral character. And if that's the case, that's what we're here to hopefully convince you guys of differently today, is that it's not a morality issue. Did I make some poor moral judgments back then? Absolutely. I absolutely did.
You also knew what you're doing was illegal because you structured your deposits and so forth to avoid triggering the IRS as well. Is that correct?
Well, there's a really weird, so that law there, and I'll be blunt about it. If you could see the actual transaction that took place, I took money out of the business bank account and had it issued in cashier's checks, because I was dealing with a programmer that was paying for programming work. He only liked to be paid in cash. That's the only way he would be paid. I still documented it and everything that I did legally, and all my bookkeeping and everything. But I was meeting with him in Detroit to go over some programming work that he had done. I was taking him some cash. In doing so, the bank didn't have the cash on hand to give me. So my banker recommended that I take 4 cashier's checks out for $9,000 apiece and give them to my employees and let them take them to their prospective banks to get cashed for me. So I literally took the money out of my bank account, had cashier's checks drawn to my employees. They took them to their bank and had them cashed, and that is a money laundering charge. And we were trying to avoid filing that IRS report that's generated at $10,000. But the only reason we were trying to avoid it is because we were mistakenly thinking that if the employee cashed that check for more than $10,000, that they had to report that as income. I'm not hiding from that. That is something that I did do. But it was money that was in my business bank account that I was taking out to conduct that transaction with.
But you could have wrote the checks to yourself and went to those other people's banks and cashed them. And
They
instead,
won't cash They won't cash a check at a different bank. Like
Not for that amount, no. But you put your employees in jeopardy by getting them involved.
Yes, I did.
What will you be doing for this company?
Sales. Sales. Sorts.
Same thing.
What industry?
The electrical industry. I do a little bit of freelance work for an electrical contractor, trying to sell some work for him.
Not the same thing, is it?
No, I wish that would be, I would be generating a little more income if it were the same thing.
Why don't we hear from the owners?
Sure, I'm actually Dan Jernigan, the operations manager. But I jumped at the opportunity today to be able to speak to Jason's moral character. I've known him for 10 years, and probably the best way to, I guess, explain my experience with him is to start from the beginning. 10 years ago, I started with Guardian Systems as a telemarketer. I didn't see or really know much about JT then. I didn't deal with him intricately. I'd see him come in and shorts and flip-flops on Fridays to pick up a check, but that was about all I saw of him. And then, as you guys can see in his record, he went away for a couple of years. Business went on as usual. We had a little bit of growth. I was able to get promoted into more of a managerial role, and I was running the technicians and the office staff at that time. And then JT came back, and I'd never, like I said before, worked with him. And when he came back, he was kind of a pain in my rear. He was always fussing about what my technicians were doing. He was always fussing about why is his job's not getting done, why are my customers' expectations not being met. I just thought, this guy's he's a jerk, he's a pain. One day he came in and he sat me down and he was like, Dan, let me explain to you about what I'm doing here with this company. Let me explain to you about the brand that I want to build, the direction and the vision that I want to take this company in. And I said, sure, man, give it your best shot. And I was young, cocky, 20 years old. I thought I knew everything. I thought, what's this guy going to tell me? But he said, Dan, I'm going to tell you a few things. I don't want to tell you how to do your job, but I want to point some things out to you as far as the direction we're going. And then he started to tell me how to do my job. And he said, what we're going to do is we're going to clean up your technical division because I want to sell to an upper echelon of customer. That's the only way we're going to get out of this little bitty office and get into a big office where I can bring the kind of people I want to do business within and be proud of that. So first step is we've got to be able to manufacture what I walk in the door selling to them. People don't buy products from me, Dan. People buy the belief that I have in our company. I said, okay, what do you believe about our company? He's like, well, the first thing is we've got to have honesty. We've got to be professional. We've got to have integrity. And we've got to execute the plan. So the first thing you're going to have to do is you've got to get out all these non-hackers that are not waving that Guardian flag as high as they can. Those people are killing our business right now. And when you do that, the cream's going to rise to the top. I looked at Jason. I was like, well, he looks like he knows a little bit about cream, so I'll listen a little bit more. He said, the next thing you got to understand is your people are going to respect you when they see you cleaning house and they see you working toward this vision that we're going for and growing our business. They're going to give you that respect. And with that respect, you're going to have to understand you're creating a family-type atmosphere. Now, in that family-type atmosphere, you're also going to open yourself up to new experiences that you haven't had before. You're going to have technical staff. They're going to come to you, all kinds of employees. They're going to say, hey, my car's broke down. Can I borrow money for this? I need a pay advance for that. He said, Dan, if those people are taking care of you, you're going to take care of them because that's what a family does here. You take care of your own. So I thought about it for a little bit. And he said, you know what, Dan, I don't know if you're getting it. He said, but I'm going to show you what I'm talking about. And so he said, I understand you're in the market for an engagement ring. I said, yeah, I'm looking. Haven't found anything for my price range that matches what my future fiance would like to have on her finger. He said, well, how much money do you have? I said, about $2,500 I've saved up. And he said, okay, get in the car. I'm like, oh, wow, where are we going? So we drive to his friend Buck's jewelry store, and we walk in the door, and he said, Buck, this is Dan. He's part of the Guardian family. He's one of our own. I want you to take care of him. Buck said, okay, he's one of your own. Dan, go pick out the ring you want. So I went, and I was like, well, this is kind of what she's looking for. How much is that going to cost? He said, how much do you have? I said, I've only got $2,500. He said, well, you got a ring. I was like, oh, okay, cool. I take it out and have it appraised. It appraised for $4,500. And at that point, I realized what he meant about taking care of your own and taking care of your family. And I took that lesson with me, and we've experienced huge growth in our company. And a lot of it's been due to him mentoring me in the direction that we want to go and building our brand and just hammering home those key issues. When he walks in the door, just like I told you, he's selling professionalism. He's selling honesty. He's selling integrity. He's selling execution. And that's, I believe that. I believe that in him. And that's why we're here today to take care of our own. He's part of our Guardian family. And, I appreciate you guys hearing me out.
You're working for the company now and have been for the last few years.
Up until we got the cease and desist.
Once we got cease and desist,
year and a half ago, 2 years ago.
Right. We at that point in time, when, if I can speak to that, Jason, when we got the cease and desist, we did try to do something where he just sold audio video until we got things cleared up with the board. But then there was a couple old customers that would call him about security, and there was one email that I caught wind of where a customer was asking him about security, and I didn't want to take a chance. We'd already paid a real hefty fine for the penalties and things that we had with him working, being unregistered when we thought he was registered. And so we paid. So at that point in time, I made a really difficult decision and basically fired my brother then and said, "You can't work anymore for Guardian, period, anymore. You're gonna have to go find something else to do." We knew it was legal for him to sell audio video, and he's really good at that as well. But at that point in time, we said and so it's been about a little over a year now that we've had that. We've documented all that to where no more email address, no more business cards. Everything, we got rid of all that. If I can speak just a minute, I'm a little bit biased. I'm his brother, but to be honest with you, since we got the cease and desist, and since I did fire him, in all honesty, my life's been a lot easier because me and him, we struggle a lot fighting together about the way the business should run and the way we should do things a lot. But I don't have any other employees, and I've got 40 employees. Or approximately somewhere around there, 37 to 40 employees. I don't have any employees that do as much as what Jason does in the local community. He's a member of our Smyrna Independent Merchants Association. He's one of the founding members of it. He's on the board. He sits with that. He helped start a 5K run for domestic violence where one of his friends had been killed by a boyfriend of hers with the YMCA. He's very instrumental with the YMCA. And he does more than any other employee I've got with his own free will and time. And so when it really came about good moral character, really, when it comes right down to it, as far as what he gives back to our society and to our even our industry, he's a great representative in our security industry while he was working for us. He's one of the most knowledgeable guys in the security industry I've ever worked with, and knows more than probably I'll ever know because he's just that gadget guru guy that understands everything from access control to fire to security. He knows how it works. He knows the intricacies more so than anybody else I've got. And to me, our country's built on giving second chances, and this is an industry he loves and he wants to work in, and he wants to be a part of, and that's why we're here today. I'm not so sure it's best for my mental state and my emotional state to be able to get him registered and get him back with our company, but that's just what he loves to do, and he was a great instrument in helping grow our business for many years before we got the cease and desist.
Guys get copies of the reference letters in the packet?
One, we don't have the additional one.
Would you like the
As the state
additional?
representatives.
Yeah, Mr.
Yeah.
I think Spot.
The other one's a town council member that I serve on a couple of nonprofit boards with from Smyrna.
my opinion, just from what I just heard and what I read, you know, you're a guy who won't be stopped. If we decide to let you in this industry, we want you to do a good job. You're gonna represent us.
I don't have any unhappy customers, from the years when I was doing business. Of course, there's a few that are unhappy with maybe the product that they received at the end of the day because something went wrong or the design wasn't, but I've never done a customer wrong or made them mistrust our industry.
I don't think that's probably the issue. I think that you're creative. Pretty creative.
I feel somewhat compelled to step in here. Mr. Thomas, you may be a great guy. I don't know you. But we're here today talking about moral character. I've been on this board 10 years. But I also am on an upper management team at a company called ADS Security. And I know that you applied with our company this year.
A couple years ago, maybe.
I know that in that paperwork that I had that opportunity to
Actually, I don't know if it was as much as an application as they pursued me. I think, yeah.
However you want to put it. You stated in an email that I read that you were licensed with this board.
At the time, I thought I was.
No, sir, you weren't. I was on the board and I checked it out. So at the time, you were not licensed with any part of this board whatsoever. You had been denied at that time. So to sit here and talk about moral character in our industry, it's just not going very far with me.
I think that may be a misunderstanding because I was not. At no point in time did I think I was not licensed. When I became aware that I was unlicensed is when we got the cease and desist at our office a year and a half ago. That's when it became evident that I was not licensed because I had a license that we put in place in 2003, I think it was 2004, and we thought that had continued to be renewed all of these years. And even when I became indicted in 2004, I think it was 2003, whenever that was, I sent all of that paperwork to the board for them to review. So they had all of that paperwork.
If I could speak to that just a minute, there was mistakes within our office. We had an alarm contractors board investigation on our company because we had a complaint from a couple of former employees that had left. And they came in, I believe, I can't speak exactly, but I'm pretty sure it was around 2007, 2008 when they came in and did that. Jason was working for us at the time, and from all we knew, he was registered. He had his ID, and that was the ID. And matter of fact, when he even went to prison after he was actually officially indicted and went to prison, we turned that paperwork into the state stating that he did at that point in time, but we never got a cease and desist, anything, but he was in jail, he wasn't working for us. And what happened was when they even did the audit in 2007, 2008, the mistakes that we got penalized for, there was nothing that was listed within those mistakes that Jason had done, and there was you didn't even catch at that point that he wasn't registered when they came in and did the investigation. There was Mrs. Weaver, or Mr. Weaver, Lori Wilson Weaver, that came in and did that, and we did think that he was registered the whole time. At no point at all did we think that we had somebody that was unregistered working for us all that time. We paid a lot of fines at that point in time as well.
Whether you thought you were or you weren't, I can't speak to that, but I was on the board at the time, and I was given the task to investigate Mr. Tolson and what was going on there from ADS, and from that standpoint, you was not registered with this board in any way at that time.
I was not aware of that.
And was claiming
apparently we weren't as a company, even after being investigated and having the investigators come in and look through our records. I was fully, I wouldn't have been out here, representing that I was registered if I was not. I did not, at no point in time did I think I was not registered.
So you're saying 2000, how long has your company been registered with this board?
Oh, gosh.
2002?
Well, we incorporated in 2000, 2001 when we went from Guardian Systems LLC, and we incorporated, and I believe that's when I guess, so it's actually probably been since 99 or 2000 since Guardian Security
So
Systems
you've been
LLC.
consistently licensed, no lapse, no nothing, up until this current
No,
day?
we had one where we were really close with Beth, where we had a QA that left us. We were really close to losing our license, but we got our QA finally passed the test within about a 5-day window.
Okay, next question. You just
Okay.
said that Miss Lori Wilson Weaver
Weaver, yes.
came out and that even she didn't pick up on the fact that your
No.
company wasn't registered.
No,
but
no,
yet
no,
she-
that he wasn't
But I
registered.
wasn't registered.
We had a couple of people that we got penalized for that weren't registered within the 30-day period, but we never had anything that we got penalized for having Jason or working for us, and he was all part of the list of the employees. I mean, everything we did was all open book. We weren't trying to hide anything whatsoever at all. We really honestly thought that he was registered at that point in time. We had a really bad way of being able to go through and do those renewals each year. And we got caught with a couple other people that we didn't renew, that we were supposed to renew, that we got penalized for back then. And we went through a really rough road there. And in all honesty, we thought he was registered the whole time.
You have been a registered employee at one time?
Yes.
And
You
what
had an
were the dates?
identification
What were
card?
the dates on that?
I don't know. It was a long time
It
ago.
would have been 2002 to probably 2000. I think we kept paying for the renewals even because I went to prison from 2002 to 2004. So
Okay, so you
I
were
think
in prison
I think
for-
we even paid for renewals while
No,
I
if you put your name, if your brother put your name down as an employee register and paid the $50, Mr. Gillespie would have caught it. He would have called you and said, "This man's not registered. There's no sense in paying for him. Take him off your list."
Oh, well, no, Jason was registered before he went to jail. Before he went
Did
to jail,
you
he was
notify the
registered.
state upon his conviction?
Yes, we did notify upon the state.
even sent the state the records of
At that
my
time, your
pending
license,
indictment.
your employee registration was canceled.
If they canceled it, they never told us.
So-
State law says that it is.
We received a termination notice.
That's
Right.
correct.
Okay.
Best I can tell, 2/28 of '05, and it said he was terminated 4/20 of '04.
But you were terminated in '04, and they received a letter in '05. So after that, when you applied with ADS, you knew you weren't registered.
No, I did not.
You even told on yourself, "I'm not registered."
No, I did not.
But therefore, you tried to
Oh,
withhold yourself, hold
so
yourself out with a shingle
if
saying,
you
"I'm
saw
registered."
an email that said that where I said I was not registered, or you saw an email where I said I was registered.
He was registered.
Right.
And you've
Right.
not been, so you've not been registered with the state now for over 12 years. 05.
5, yeah. Well,
Not
05 would
not
just
12
be,
years, but 8 years.
So it's been within a 10-year period that you said you were.
And according to Mr. Harvey, within the last year, 18 months, they've received a letter in which you state you are registered with the state of Tennessee.
That was before we received my cease and
That
desist.
was, that was an email.
That's
Yes.
correct, but your license were terminated in 05.
I
Y'all
had,
sent-
I'm.
We did,
We
we
did
did
not
not
know
know
anything.
Y'all
anything.
sent in a termination notice. How can you say you didn't know he wasn't registered?
We don't know who within our office did a termination notice. We would have thought,
David
when,
Parker.
in all honesty, I mean, we were,
David Parker.
yeah. And in all honesty, our business at that point was very small. We were not very organized as far as keeping up with our registrations. We didn't even try to start getting more organized until Lori Wilson Weaver came through. By any way, I'm not trying to misrepresent. We've got all of our other employees registered. I mean, we may have slipped upon going one past 30 days, but in no point would we have let somebody continue to work for us that long without being registered. We just all assumed that he was still registered, and I don't know where the cease and desist came in or where the termination notice came in when David Parker was our QA. I don't know how that came in, but I do know that when Jason went to jail, David Parker was our QA at that time, and he was the one that actually sent the paperwork into the state from every record that he's ever told us, and from our knowledge to state that Jason was convicted at that point.
And when I returned, David Parker wasn't working for the company anymore.
So I don't know if
It just seems like an ongoing snowball, for lack of better words, that you've tried to pull the wool over people's eyes, starting with the state, then with your employees to keep their job. They did what you asked them to do. A lot of people would have, and then it goes to the IRS. Try to pull the wool over their eyes. Now you're trying to pull over the wool over the state's eyes, and future employers.
Sorry if that's the way you feel, but that's not. I honestly
Feel it's the way it looks.
Well, I'm sorry if that's the way it looks.
Even on paper, it looks that way.
But that's not the case. I honestly
Do you not
thought.
understand the process that this registration is required every 2 years on employees?
Oh, yeah, no, we've understand it very clearly. We've written some really big checks for the mistakes we've made. So we've got a very, very detailed process that we've got where we check all our employees. We cross every T, dot every I.
You've not sent
now.
an employee registration in on your brother since he was terminated in 2005. How can you even begin to think that we should believe you that he was licensed and registered and everything else for the last?
From what I understood, when David Parker, I guess obviously sent a termination in, from what I understood, David Parker had sent in paperwork showing that he was convicted, not a termination notice. I never knew anything within our company that he sent a termination notice in. I was always told by David Parker Jr. that he sent in the paperwork. I didn't physically look at that myself or do anything with that. He was our designated QA, and he was in charge of handling all that for us. And from everything he told us, the other partners in the business, Jason had, as soon as Jason got convicted, he sent paperwork in for that, because David Parker was always attempting to try to do everything right as far as the Contractors Board goes, and he's been a QA a really long time within the industry. As a matter of fact, that's why we brought him on and hired him, because he'd been a QA for so long and he knew and understood all the laws.
But he did the right thing. I don't have a question about that. My question is, after 2005, when you continue to allow your brother to work there in a registered employee capacity until the state comes in and tells you to cease and desist. How long was that? Was that like 2012?
2012 is when we got the cease and desist, I believe. I don't know exactly.
For 7 years.
7 years he worked in the industry and
illegally, and he's required to be re-registered, but yet y'all just didn't pick up on that.
In the middle of that,
And as smart as you are, I don't believe you. Now, that's my personal opinion.
well, I'm sorry you feel that way, but it's the truth, because I wouldn't have. I mean, there's no way that I could have been out there, especially going after the large corporate customers that I was, and been misrepresenting that. I mean,
I have any more questions for this gentleman or any of the parties here?
Commission members, we're having some documents copied for your review before you make termination.
Just a copy of the termination notice received in 2005 and some other documentation, but Hannah should have it back shortly.
She's going to have to make copies for us. Let's take about a 10-minute recess. Thank you.
You've already had your recess, Tucker.
Yeah, no, I don't need one. I needed that. And then she brought me no, I don't want any more water.
Crushed
I
while
drunk
you were
it.
sitting there.
Special.
Versus water bottle.
I had one. Out of the whole box. She shares so well.
Scarf them down.
Yeah, well, I kind of eat half of them on the way here.
You have any other personal problems? Let's don't go there.
Or jabs, you don't have time for that.
Don't get her started.
Thank you. Yep.
So where did you end up staying?
At some.
there is conversations. So there-
Whatever y'all want to do, but we're not bringing lunch in.
where did the train come off the track?
I think I stayed there.
Did you see Best Picture?
I stayed there, yeah, like.
Yes, you showed me. It was good.
Daddy's grin.
Well, he looks like he's doing good.
Well,
Your daddy.
he has his, he can go for a little while, and then he has to stop and recharge, and go a little while and stop and recharge.
He looked good in that picture.
He was happy, wasn't he?
Yeah.
I think that maybe been after him and Ken had been outside with the open bar.
Oh, that probably did it. The open bar.
And having his arm around a pretty woman like Penny.
Documents we've been handed.
Termination. Business rent from 98.
The record, looks like the board is reviewing documents, a letter from Mr. Tollison, Jason Tollison, explaining the legal charges dated 2002. And then, looks like the next correspondence we got related to this matter was the notice of termination that you were discussing earlier. Says date of termination was 4/20 of '04 that we received in February 2005. And I believe that was the last documentation that we received until 2012 for a new registered employee application.
That I was not licensed.
Guys, have paid some fines, haven't you?
Yes, sir.
Was the badge turned in?
And if I could speak to,
Registered employee.
No, that's all we got.
That's-
We get the badge.
Yeah. So he kept the badge.
I don't know what happened to it.
I think at the time that he turned, obviously whatever that year is that he turned that in for me, I was incarcerated at the time.
and from my understanding, I didn't know that he had turned in a termination. I thought he'd send in the paperwork as far as turning in the records, because that was what we had legally were required to do once he got arrested. And from my knowledge, that is what we did. And understand, I hate to be in a situation to where Jason gets punished for my company operations mistakes and problems in making sure that he stayed registered. And that's what I feel like we're kind of leading to. It wasn't his fault, and it wasn't his responsibility to make sure that he kept registered. It was our responsibility that we did that. And in all honesty, I truly thought those years that he was still registered, even when Lori Wilson Weaver came in and did the inspection, there was no things of, I mean, she went through every file. This was like a 2-week process we went through, and hours upon hours within our office because of a couple of complaints that had came in from people who had left us. And one of those was David Parker Jr. that had put in the complaint when he had left us. And that's why we went through all of the investigation at that point, and there was nothing that came up, and she didn't even catch at that point that Jason wasn't registered. We
But it
did make a
doesn't matter whether
mistake.
she caught it or not. He
Yeah.
knew that he wasn't registered.
No, I did not.
This piece of paper didn't give you no clue.
I thought reporting that I was under indictment was, I didn't know that would automatically deny my registration. No.
This didn't deny you, it just terminated you.
Right.
Right.
But with previous experience of my employees, I can terminate them, but if they're upset, they'll keep the badge and they'll still try to work.
Oh, well, I haven't ever experienced that. I've never done anything to get badges back from somebody when they've left employment. If that's part of the law, I'm sorry, I did not know that I'm supposed to get the badges back. I don't know that we've ever done that.
Right now, it's a fact that on 2/28/2005, you were terminated. I know the dates are off. It looks like 4/20. Somebody didn't send it on time, but the only facts I have in front of me is that you haven't been a registered employee since 2005.
Looking back. Being aware of that at the time, I wasn't even here to know. I was incarcerated at the time.
I also have another document that is saying that it was saying that this office, due to the conviction, they terminated you, and somebody in this office followed up to make sure that they acted accordingly on it.
Again, I was incarcerated at the time, and so when I came back 2 years later, I assumed that I was still registered. I wasn't any.
Read you something that came before the board. It's a 2006 case. Complaint alleged the respondent did not have a current DQA. An investigation was requested for compliance inspection. The investigation reveals 7 employees with access to confidential information who were not timely registered, totaling 20 months. Additionally, the investigation revealed an employee with access to confidential information who was convicted in federal court for conspiracy and structuring transactions to evade reporting requirements. Out of the 8 employees not timely registered, 6 have become registered, but 2 are not registered with the state. Now, this, according to this document, was August the 10th, 2006. We're 7 years later, and y'all are wanting to claim that this man has been registered and you didn't have any idea after this compliance inspection was conducted in 2006.
That's the one from Lori
We
Wilson
did
Weaver, and
find
it
it.
did have Jason's
Right.
name on there?
She found it.
2006,
Well,
they
how
brought it
many-
to your attention that you have somebody convicted of a felony, and it's documented in this report. It's a legal document. 2006.
I honestly, in all honesty, I don't remember that document whatsoever at all. I mean, I knew that we made mistakes and I knew we paid the fines for it.
2008, out of 8 employees, 6 are registered. There's still 2 not registered with the state. There's 3 different times that this case has come before this board, dating from 2006.
I don't ever remember coming before the board for this case for Jason whatsoever at all for
This
anything.
case has been before the board 3 times. It's not saying you have been here, but we've reviewed material matters involving your company 3 different times because of unregistered employees, and as early as 2006, it was documented that you had a person with a felony conviction who had access to confidential information.
Does that say that was Jason?
Well,
How
I don't
many
know
more
if
do you
you got
have?
anybody else
Do
convicted.
what?
It lists-
We've
How
had-
many more do you have
Obviously.
I don't have anybody. I mean,
with that federal conviction?
I don't know about federal convictions, but we've had other people that we brought before the board and got approved.
Who was convicted in federal court for conspiracy and structuring transactions to evade reporting requirements.
Right.
This is 8/10 of 2006.
So we've had more than one inspection from
This case, starting in 2006, has been before this board 3 times.
You've had more than one request for him to get registered, not that you have personally been here 3 times.
He was denied.
I don't know of anything
Talking
we ever
about-
did to try to get him registered.
You're talking about one complaint,
case.
right? One complaint about the company not registering employees. which is true. And then we're talking about the 2 times that Mr. Tollison has registered, but what we're here about today is his newest application for a registered employee.
I understand that, but they claimed they did never know that he was not a registered employee. That's my
Yeah.
point with this.
Yes, ma'am.
I
Trying
understand
to
we're
get employment
here
with
to
other
den-
companies saying he was registered.
That's my
I was
that's
not
my
aware about-
thing.
I was
This
not aware
started
about-
back in 2006. This didn't start in 2012 with him having problems being not registered.
Oh, yeah, I'm not disagreeing with that.
It's his application they're
That is correct. We know it's his application. I'm basing it off of statements they've made that they didn't know he was not registered.
This application's been rejected because of moral character, correct? Okay.
Yes. Do y'all have any more questions for anybody in this? Is-
Make sure I understand what we're dealing with. I think Josh has brought us kind of back on target. Basically, and let me make sure I understand this, so correct me if I'm wrong. Mr. Jason Tollison was rejected in his application for a registered employee. Is that correct?
Yes, sir. He made application on August the 7th of this year.
Okay, and
registered
because of
employee.
his past record, it was declined, cease and desist was sent to the company, and now they're back asking us to revisit that decision. Now, that decision was made administratively. So this case is not, this specific instance, this specific application has not been before the board before. It was administratively rejected, and Mr. Tollison, the 2 Mr. Tollisons, are now asking us to revisit that, reconsider it, and grant his registration. Now, we've had a lot of other discussion, but I think when we get down to the case, that's the matter we're considering. And we are to make a decision as to whether or not we feel like that Mr. Jason Tollison has sufficient good moral character to be granted a registered employee status. That correct?
No, that's not exactly accurate. If the way I understand it, he previously made application. It was dated November the 1st, 2012, and was denied. It appeared before the Systems Board in which it was applicant did not meet the requirement. This is the second time they've been before. This matter has been before us specifically
Okay.
pertaining to
Okay.
this.
So, now, what was the date on that?
2012.
A year ago.
When we came before the board for then, at that point, we brought our QA to be able to speak towards his good moral character, and we didn't do that. And then there was a comment made that he was being denied because of felonious assault. So, and there was never any kind of felonious assault. It was the only thing that he really could be denied on that we could find would be on the good moral character. But there was it's in the video of that there was a statement made that it was being denied because of felonious assault, and there was no felonious assaults. That's why we got to reappear. I believe that's why we got to reappear today. We don't know.
I don't think there'd be any indication of felonious assault.
The reason that they are reappearing today is because they've made new application as they are entitled to do, but it is true that they have been before this board before and were denied for poor moral character.
What?
He
Okay.
said
He
that
has.
somebody made a statement that it was because he had a felonious assault, so reason but there's
what-
not
That, there may have been a statement, but that was not,
That's correct.
I mean, I think it was a misstatement.
And what will we make the judgment on moral character based on the past, correct? We will make that decision based on the past.
Yeah, okay, so let me make sure I understand. So this was presented over a year ago and denied because of poor moral character. Yeah, well, I thought
is
that
correct.
clarifies things a bit.
Yes.
I thought I remembered
Yeah,
the situation with the cards and DirecTV because.
Right.
And I'm thinking surely there couldn't be two of these guys out
Well, I
there.
don't think it was ever clearly defined last time as poor moral character. I think last time you guys were looking, which is much like what you're doing today, you're looking more at the criminal history of 10 years ago.
No, it says at which time it was agreed that the applicant did not meet the requirement of good moral character as set forth in TCA 623212E2. That was the same issue in November 2012 that we're faced with
Okay,
again today.
and since then, they've made a reapplication, as they're entitled to do, and asking, and which was administratively denied, and which was not an unreasonable thing to do. And now we're asking to consider the second application of Mr. Tollison to become a registered employee.
That's correct.
Okay, and we finally,
And there's
finally
one,
getting it straightened out, I
and there's
think.
one step in there too that once we had been denied before, our next option before that we had talked to Mr. Simpson about, the only thing in the law that says we could do was go to Chancery Court, which Jason hired his own attorneys to do, and go to Chancery Court. But the filings were a couple days late, so it got kicked out of Chancery Court at that point. So I just want to let you know there was another step that we actually went through before we reapplied. When we got kicked out of Chancery Court, the only other way that we could go through the process again was to put another application in, because we were the lawyers filed I think it has to be within 30 days of this meeting to be able to file with Chancery Court, and we missed it by 2 or 3 days, or his lawyers missed it.
Didn't know that. Thanks for the information. Okay, so maybe I'm clear on what we're doing now. At this point, we're considering his application for registered employee, which has been previously denied once by the board and once administratively. Okay.
I guess it'd be twice administratively, correct? The first time before, and then it came to the board, this time in the board. So there's been 2 administratively and 1 board denial.
And even though we may be critical of some of the company's activities in the past, that's not really the matter it's not really the matter that we're discussing at this point. Tough call. Board has to make some tough calls sometimes.
What I'd hope is that y'all would look past the 10-year previous criminal history and take some of that testimony and some of those letters of reference that I've got. Let those speak as to my good moral character. I mean, we all make mistakes. I made mistakes years ago, and I regret them. But I honestly thought that I was a registered employee for all these years until this time.
And understand with Representative Sparks, he's known Jason since he was 8 or 9 years old. Grew up in the same neighborhood with us. It wasn't just a letter from a state representative where we'd reached out trying to get some help. He's literally known, and so is HG from the town council. Jason's only known him since he was 16, but Jason worked for him at his Lube Pro shop when he was 16, and has known him since then. It wasn't just where he'd reached out to try to get something to where it looks good from somebody that's a state representative. It's somebody that actually does know him. Both people have known him a really long time. And State Representative Sparks wanted to be here. He just had a conflicting thing, and it was such a quick turnaround.
5 days notice
We
to
had
be
5
here,
days
so.
notice to be here. He just couldn't work it out with
He
his
wanted
schedule.
to be here to speak on my behalf, but
Well, the board does consider letters of reference from people. The board does consider the time issue, the time that has elapsed between a particular offense and an apparent lapse in good moral character and the current time.
Did he submit another letter besides the one in your
no,
packet?
he didn't have time. He was going to, and
Oh, I
by
know
the-
he said he was going to appear. but
I think he actually said that he was going to actually send some letters directly to y'all. He wanted your contact information, was going to try to attempt to get them to you fast enough before we actually got before the board. And I don't know if those actually happened or not.
Receive those.
No, that documentation need to come to the board office.
That's correct.
Well, here's where I'm coming from on this thing. There've been obviously lapses in moral character. There's been a lot of questions. You've been had a number of questions asked. Basically, the question in my mind is whether or not Mr. Jason Tollison would be a suitable person to be in the alarm industry. whether he would be a potential threat to people needing alarm industry services. And even though I am disappointed in some of the obvious past behavior, I don't believe that Mr. Tollison would be a problem or for the general public if he were allowed to be in the alarm industry. And it's my opinion, and I have only one vote on the board. I would therefore make a motion that we grant Mr. Jason Tollison's application as a registered employee.
Okay, we have a motion by Mr. Roberts to approve Mr. Jason Tollison's application as a registered employee. Do we have a second? Motion dies for lack of a second. Do we have a motion to deny?
Make a motion to deny.
We have a motion by Mr. Harvey to deny Mr. Tollison's employee application, registration application. Do we have a second?
I'll second.
We have a second by Ms. Jones. All in favor, voice by saying aye.
Or what,
Aye.
on what grounds, for the record?
For the record, it will be continuing for the moral character, good moral character. Vote again so that it'll be more clear. All in favor of the second motion to deny this application, voice by saying aye.
Aye.
All opposed?
No.
Okay.
I'm sorry, Mr. Tucker, I didn't see Mr. Tucker vote.
Mr. Tucker, did you vote?
I didn't. I'm sorry.
Please express your oral vote now.
He doesn't have to vote if he doesn't want to.
Well, he doesn't recuse.
Say he's
He
abstaining.
needs to say.
Abstain.
One way or the other.
Well, then he abstains. Right, motion carries.
Motion is,
To deny, three voted for that motion, one against, and one abstained.
thank you.
Thank you for coming today.
Okay, it looks like we had another appearance, like I said, at Mr. Evans, but today.
I think he's about an hour and a half late there, give or take. We want to move forward to the next one in the,
We're going to go straight into the employee applications, and the first one is Ray. And this is for Mr. Chase, who you're going to review his application, but he is here in case you might want to
go ahead and
ask
have
any
us,
questions.
have you signed in, sir? Okay, just have a seat and give us an opportunity to review the file, and we'll be with you.
You already signed in, Mr. Chase, early this morning.
Excuse me.
Ask a question. Okay. I see a letter about the situation at this college, but failure to leave the scene of an accident. I don't see a letter or anything from anybody, maybe with any reason for that, or
It was a single vehicle accident, and there wasn't any damage.
why did, okay. I'm looking for a letter from you why you left the scene.
Do you have any written explanation explaining the circumstances in your individual charges?
I had emailed one a couple of days prior to this.
I know a lot of times people will either forward us, it provides some more of the details other than just the formal charge.
I see a
The,
small
the
one
charge
on
you're
page
referring to was kind of bundled in with a few charges. It was a DUI.
Yeah, there were several charges in 10.
A couple of them got dismissed. They didn't dismiss the leaving the scene of an accident.
So did you provide, you said you emailed it in that provided some explanation?
Yeah, it was
circumstances
to
around it?
a Beth Bell.
Is that in our file, do you know?
I don't have any recollection of getting it. I got the letter from the qualifying agent.
Okay.
We got his letter from May the 28th, but I don't have anything further, more than that.
Got a letter.
Recall when you sent
No, I
it?
just got the letter from the QA at the very
The
back,
QA?
on November the
To my
7th.
concern, right.
Beth S. Bell at tn.gov.
That's
I
a girl
don't
that
have
played the prank
anything
on.
about leaving the accident of a scene, the scene of an accident, though. I don't have anything on.
Actually, why I brought it before you today is the guilty of criminal impersonation, not the DUI.
Robertson, but I don't have anything else.
And I guess what I'm looking at, Madam Chair, is failure to report an accident, leaving the scene of an accident that's very recent. 2011.
The incident occurred on October the 24th of 2010. It was just in court for a while.
What happened there?
I left the house with a couple of two drinks too many, and I wrecked into my neighbor's yard and pulled out and went home. There wasn't any damage to anything else other than my car.
Who reported it?
Leave one of the neighbors in the neighborhood. I just thought I could go back the next day and tell him what happened and, clean up anything if there was something, but there wasn't any damage to his yard.
Oh,
Mr. Chase, would you tell us a little bit more about the criminal impersonation situation?
I was in college at the time, had a girlfriend that became an ex-girlfriend. I had her login information for the college, and I dropped her from a few classes. For her to re-enroll, charges had to be pressed for criminal impersonation. I served 2 days in jail. I have a letter. I have the original from her that's notarized and everything, stating that there was no monetary loss or gain in the situation.
Kind of mean-spirited, wasn't it?
It wasn't a good time, I guess. I didn't think anything would really amount of it, and when it occurred, I can realize why I guess they pressed onto it. And it was also information that she had given to me prior to that. It wasn't anything that I went into her purse and found or anything.
It's the reason for which you use that information, not how you obtain it.
Correct.
Dropped her out of some
Enrolled her from
classes.
college.
Enrolled.
Oh.
How long have you been with the alarm company?
I tried to start working for them about a year ago, and during my application process, they told me that I couldn't work until it was approved, and then I received a cease and desist actually in the mail, I believe in March.
What have you been doing since then?
Mowing yards, I've sold a couple of my vehicles, and I'm blessed to have a girlfriend that has been taking care of me for a while, so.
Maybe she ought not give you a computer login.
I think that's a different one, isn't it? Is this a different girlfriend?
Yes, ma'am. A lot changes whenever you serve a couple of days, trust me.
You, so you haven't worked for the alarm company since when?
Probably, I'd say April. That would have been the last time I received a check. I have recently been approved. I got registered in Virginia to work, so I was going to start working in Virginia representing them.
So you're working for them still?
No, I'm just trying to work for them. But I got my registration for Virginia.
Another state for the alarm company?
Correct.
I don't have any further questions. I don't see any reason that something that happened that long ago, of course you won't do that again, that we should deny this gentleman from having his registered employee, being a registered employee for the alarm company. Besides, he could be working for the alarm company right now.
So you're making a motion to approve his employee
Yes.
registration application?
I make a motion to approve this employee.
Okay, we have a motion by Mr. Tucker to approve this employee registration application. Do we have a second?
Second.
We have a motion by Mr. Tucker, second by Mr. Roberts. All in favor, voice by saying aye.
Aye.
All opposed? Congratulations, and
Thank you very much.
please don't disappoint us.
Don't leave the scene of an accident.
I'm sure those two charges come together quite a few times.
Only with you, though. No, good luck, man.
Thank you.
We'll notify you what other steps that we need to do. Thank you. All right, thank you for coming in.
Might stay for the football game.
All right, good.
Oh, do y'all have,
No, they're.
Y'all are just here
They're here
for-
for continuing education.
very good.
How's it going so far?
You're not going to install any CCTV, right? No, I'm joking with you guys.
Oh, that.
I know. Hey, they were taking notes when they heard that. He said, wait a minute. A part of the burglar
All right,
alarm?
we'll just move right on then.
That's
That was-
correct. We have application file K.
Number
Because we don't have an appearance, do we?
That's all we had. And I brought that one before you today because of the assault
Still
charge.
melting in my hand.
Guilty of assault charge.
Okay.
Make a motion, we approve Mr. Huffman's employee registration.
Second that.
We have a motion and a second to approve Mr. Huffman's employee registration. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Okay, thank you. The next one we're going to go to is L.
The contractor on this one, does that say Comcast or a separate company, an individually owned company?
It's Comcast.
And then
What
it
is
says
application?
DBA
Broadband
something else.
security.
Well, that's their
That's their
DBA,
DBA.
yeah, Xfinity Home Security.
Broadband
Okay.
security.
I couldn't read the print, I'm sorry.
I saw that on a billboard. I didn't even know Comcast and Xfinity was going into security.
Right at the very back, that says, well, you read it, but.
I brought this one because of the 2008
right.
possession.
Mm-hmm. Night before. Boy, that must have been a good one.
Paraphernalia mean the stuff to use it with? Not
Assist in the drug use, yes.
A question for administration here. His letter, as the QA for Comcast, I'm not inclined to write a letter of awareness to the board of any knowledge or conviction.
Never write the letter.
We get this every time
This,
we have a
every time we
Comcast
have one,
applicant.
the QA will not write the letter.
That's not my question. The next sentence says, "We are taking the position of leaving these issues between the employee and the state." The law doesn't say that you leave these issues between the employee and the state. It says that you are in charge of that employee.
They
Right.
figured out a way not to be involved with this part of it.
No, they just don't want to fool with it. But I'm just saying that the employee could get their license taken away. They can't just say, well, I'll just leave it up to the employee and the state, because they're in charge of them.
They
Send them
know
a notice
everything.
That it was either denied or something.
But it also in the statute says that you are in charge of these people. You're supposed to be the one
I just guess they
overseeing
take
them,
the
isn't it?
position, they don't write letters of
Well, and
recommendation.
this goes back to something that we've had faced. Or hire them.
In a small company, they would. In a large company, they wouldn't.
They're just
And
a
most of this law was
Yeah.
tailored to like a mom and pop company,
Yeah.
because at the time, that's,
I just can't imagine having so many people under me and not worrying about them because it's your license, not theirs.
Having thousands of employees is
Really?
not within your experience, I would take it.
How did you know?
No, did I miss something that's,
It's this letter right here.
no, I found that. I'm saying,
Vivian, what's the difference between Schedule 4,
Schedule
Schedule
6 is
6, and
less.
Schedule
Yeah,
6?
they
Schedule
go
6
less.
is less.
Yeah, they go
Schedule 6
less.
has low risk of dependency, like marijuana.
Madam Chairman, I make a motion we grant this application
I'll
to
second.
registered employee.
okay, we have a motion by Mr. Roberts, a second by Mr. Tucker to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
All right, we'll move right on to M. Morales, I believe that name is there.
Monitoring Center?
I brought this one to you because of the guilty plea for robbery in the 3rd degree.
He works in the Monitoring Center.
She's, yes.
Okay.
ADT Central Station in
Right.
New York.
Best date was 1996.
Yes, it was 1996. Had a firearm too.
Didn't have anything since then at all. He was 18. Sentenced to a year on Rikers Island. Rikers. Wow. That's such a tough prison that you don't want to go back there. Four months probation, then moved to Rochester. In the monitoring center, I don't see any reason, since this is so old, to deny her registered employee, denying her to be a registered employee. I'd like to make a motion to grant this Ms. Morales her registered employee license.
Okay, Mr. Tucker's made a motion, but I don't think the rest of us are quite to that point yet. Hold that, Mr. Tucker.
Madam Chairman, I'd second the motion.
Okay. We have a motion by Mr. Tucker and a second by Mr. Roberts to approve this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. And I think this was what, K, L, I'm sorry, this pertains to,
Gonna go
Yeah, we're
to
ready
N
for
now.
N.
Mm-hmm.
I'm so sorry, that was for M. No, we're now moving to N.
And if you would take one of these, this is related to the one you're looking at now. I just got it yesterday. I put a copy of the minutes at the very back page where he appeared before the board. May 19th, 2011, he was still on probation. That's the very back page of your stuff on your iPad.
I think it's page 12 of on our file in here. List attendance, 5/19/2011, is that it, Beth? Okay. Be number,
But when he appeared, and he wasn't granted because he was still on.
Oh, we saw this. I'm
He
sorry.
was here.
I remember this
He
case.
came in,
Right.
but you guys told him since he was on probation.
Father was arrested and yeah,
Yeah.
I remember the case.
Problem was getting the document from Mississippi saying he'd completed it since it was non-supervised.
Fees expungement.
No.
No, he just got off probation.
I was just
January
reading
this
the old
year.
letter
So
that
it's been about a year since he got off probation.
Completed probation, his probation's completed, and he's had
So-
go ahead, hon.
It was completed in January 2013, and then he reapplied. Oh,
No subsequent arrest, correct?
nothing.
Okay.
I'd like to make a motion to grant Mr. Watson his employee registration.
I'll second it.
Okay, we have a motion by Mr. Harvey, a second by Mr. Tucker, to approve this applicant's employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
We can move right on to O then. You ready? This is the one I was going to need our attorney for. Ask about this one because this one here was possession, but still on probation,
It
best
just
I can
happened.
tell.
On
But
6/8.
got a diversion. Judgment deferred, no conviction. 9/23/13.
I didn't, those
I see it on
Unlawful
here.
use, unlawful use.
abbreviations I didn't understand.
Possession.
Madam Chairman, I make a motion, we grant this application.
Second.
Okay, we have a motion and a second to grant this application. All in favor, voice by saying aye.
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 All opposed, I vote nay. You just got arrested, you. Application is granted, motion carried.
Okay, oh, what, okay. We'll go right on to P then. This is another possession.
Need to recuse myself from this application. I know this person.
Okay, so Mr. Tucker gonna recuse himself, all right?
No, he works for a company that I see him sometime.
And you,
Yep,
He's doing fine, whatever he's doing.
2003.
Tracking and fixed objects, is that hitting your car against something? Is that already in?
What is this?
Where? I didn't read it, I just,
I know.
oh, that's hilarious. Steve, did you work with this guy?
No, I never worked with him, but I've seen him with Jeff quite a few. I saw him with Jeff before, 2 or 3 times. Shook his hand, so.
And besides, you didn't inhale.
I asked him was he got
Yeah,
with
what?
him. He said
I
he'd
mean,
have fun. Was you with
You
him?
guys, you know.
You with him in the ADT work van?
No, I know Jeff Spears real well, so I know some of his employees.
I just figured you might have, you know.
I never hear that with any of the other board members, so I can't wait till I get my appointment. You guys won't be able to do me like that.
Who's he working for?
I don't know if he, looking at his phone.
But they reappointed you with me. They're like, just.
Madam Chairman, I make a motion, we grant this application.
I second.
We have a motion by Mr. Roberts, a second by Ms. Jones to grant this employee registration application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries.
You got one more.
It's a bad
Your
with that.
package. I gave you yours on the other.
Understand, when I walk in SES, these
Yes,
people
yeah.
come up and start talking to me. Hey, I got my application. They'll start talking. So this has been.
Tell them, shut up, I can't discuss that.
That's what I have to.
If you
Call
tell me,
Beth.
if you tell me
Put on
about
the
that, I'll have to
iPad.
vote against it.
I always say you got to call Beth, but it's a good thing in my area
Nothing
now.
on you
They
again,
recognize
see.
me as being somebody who's on the board. It's been positive.
This one did not make it.
Here's the rest of the
to
stuff.
iPads, and I didn't get
From the other people?
that stuff that needs to
Oh,
be shredded.
he's got a dog.
There you are.
Anything else needs to be shredded?
Things my papers from the other.
Thank you. Shredded stuff. Just this piece. I don't wanna get rid of your travel plan. Somewhere.
Clean slate. Oh my God, I'm just stretched. Another one. Comcast. Less than.
He was working
Yeah.
with somebody and.
Uh-huh.
Guy with him did it.
A motion on this person?
This is old, very old. And that was 2000. Yeah, it's 2000. That's 13 years. I make a motion to grant this employee their registered employment license.
Second.
We have a motion by Mr. Tucker, a second by Mr. Harvey to grant this registered employee application. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Education report.
Beth, did you send all this stuff to me, or did it go
I
to
sent
everybody?
it to everybody.
Oh.
I only got a response to you.
Oh,
Some of it was insufficient.
I've seen him
somehow.
here before.
I sent it to everybody.
I wondered
Now,
why I thought you was just picking on me.
No, I'm picking on
That's your
everybody.
dad? I thought he came when we were in the old building to,
I'm gonna have to
That's
look at the
awesome.
thing on the board.
oh. When you are in Franklin.
I got some problems with some of these things as they were submitted.
Well, again, if you look at your, thing, some of them, all the ADT classes that didn't have very much information,
Actually,
I have contacted Mr. Kelly.
Get the monitor.
And he is gonna resubmit additional information. I actually, if you'll notice down the list, at the very bottom, I put insufficient info on most of those. The ones that we seem to have additional info on, I left like to be presented. But, the first item on here is Mr. Crease, who is an ADT, designated qualifying agent for their central station in West Henrietta, New York. He had already taken these ADT basic courses for his continuing ed when he was advised that they had expired in 2009. So they have sent the course materials and requested that we consider accepting that just for. That was a little separate caveat I sent out separately. They were the previously approved ADT courses, but they had expired.
Do they have to resubmit for those to be?
They're all resubmitted, but the only ones I got enough information on for you to review are the ones Mr. Crease took, because he sent me the course materials himself.
Actually, I've taken those before. They're pretty good courses.
All of them?
All of them. They do thorough
Again,
training.
that might give us enough information if you know, Ken had emailed me back that with just simple course outlines, that really wasn't enough. But would you consider accepting this 16 hours to meet Crease's renewal? I think that's gonna require a separate motion.
You're talking about all 4 courses.
No, just the ones he took. He took the fire alarm inspection and testing, which was a 4-hour course. He took basic electronics, which was an 8-hour course, and safety, which was a 4-hour course. And I have his certificates of completion.
I'd make a motion, we accept these hours as continuing ed.
I'll second.
Their nicer class is good.
Well,
do
actually,
we
that's
know
where
which
Gary
ones
Kelly
we're-
was yesterday when I talked to him. He was teaching a nice
We're not here
class
that
and
Mr.
couldn't
Was
get
it?
his
We're-
materials back quickly.
Right.
Now, we're voting just,
To accept.
I'm
For
confused.
this one here.
Just for the continuing
For
ed for Mr.
Crease.
Crease.
Okay, we have a motion and a second to approve those classes by Mr. Crease for in continuing education. All in favor, voice by saying aye.
Aye.
All opposed. I didn't know if we were doing them all in mass or in sections.
I really kind of think they're all different providers, but the next thing that we were submitted was the Electronic Security Association. They have a new professional fire alarm design course. I don't know if you reviewed all the material they sent out, but they now have certifications that are similar to NICET, that they have a designated fire alarm system designer and.
You know, they're working towards being an alternate to NICET.
Right.
Basically, that's where they're
I was pretty
headed.
impressed with the course materials, and again, I'm not technical, but I asked them to submit that when I got the notice that the CFAD, the designer thing had been approved in Oklahoma, I think. Our course, they submitted it for employee training, qualifying education, and continuing education.
That's this one here, Beth.
Yes.
Okay. That, I would recommend, I make a motion that we accept this ESA course for 16 hours of employee training and continuing education. I did not think that it had enough basic information to cover the initial application.
Fire qualifying agent.
Now, to get their certification in fire, you have to also have the practical fire alarm course. You've got to have fire alarm, the FAME. There are 3 separate courses you have to get that certification in fire.
I understand, but what I'm saying is this course by
This course
itself,
alone, you wouldn't recommend for qualifying by itself.
not for initial application, no.
Okay. Anybody else?
Motion by Mr.
Oh.
Roberts.
I'll second.
Okay. And Ms. Jones seconds it. All in favor, voice by saying aye.
Aye.
All opposed.
I did not, this is not on your report, but say that I got a certificate for their certified fire alarm designer who had to complete all those 4 courses. Could I accept that certificate for qualifying without having to ask for additional information like I would a NICET Level 2 certificate?
I would be comfortable with that. My only objection to this particular course as it was presented was it just didn't have the basic information. If they've taken a basic course prior to that and submit that along with this, because this is really appears to be a good course. But it just, for somebody that just took this course by itself, they wouldn't have enough basic information to be qualified for an initial application. If there were additional courses, additional coursework taken in addition to this, then I would feel comfortable with it being adequate for an initial application.
Well, I did send out her notice that I think I included that you have to have fire alarm installation methods and either basic electronics. There's 3.
If they've got that along with this course, then they would be well qualified for an initial application.
Qualify with the FAME by itself, but if they had this certificate, I wouldn't have to ask. NICET. I've had 3 people apply with the video systems, security systems designer. Approved NICET for closed circuit television. They didn't even have a designer designation, but now they've got a designer level 1 and I printed out some information off their website. I know you're aware of this, but NICET has never submitted out and documented them so we can accept them, which is competent. I mean, it's,
They're the
Yeah.
big boy in the industry. They stay on the outside like that.
so, I went ahead and sent out information for hopefully qualifying education and continuing education in closed circuit television. Have the designer, which they have to have documented so many years' experience, so many systems as they've designed. The criteria to get either one of these two designations is pretty, it's almost
Yeah.
as stringent as the fire alarm NICET
It is.
is.
Going to request for them to send you that information.
No, I'm requesting you guys approve it because it's NICET.
That's and that would
I'm
be the
sorry.
reason. they're
I can't ask these people to
Right,
submit,
'cause
they
they-
don't
they won't.
submit their courses.
They're submitting that for continuing education.
I'm submitting it for qualifying and continuing because I have two applicants that actually have it who are applying in CCTV.
She wants us to okay it, so
Okay
we
it.
can use it for the education.
And I put on there continuing and qualifying because it seems to exceed the NTS video course and the NICET video certification and Howard's course, which we currently accept.
Madam Chairman, I make a motion we accept the NICET Video Security Systems Designer Level 1 and Level 2 as meeting the educational requirements for CCTV
a second.
qualifying agent.
Okay, we have a motion by Mr. Roberts, a second by Mr. Tucker to accept this NICET training for qualifying education and continuing education. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
The next item we have is course. They submitted it for employee training and continuing education.
You say the basic security alarm installations did not meet the criteria we've established?
Not for employee training.
For
They would
employee
for
training.
continuing education. I mean, the employee training that you've currently got approved.
This one was what, 8? 4. All right, Madam Chairman, I make a motion we accept the Jade Learning basic security alarm installations for 4 hours continuing education.
Motion by Mr. Roberts, we have a second.
Second.
Second by Mr. Harvey. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
All right, the last one that I felt like you had enough information to review was the LSS Life Safety Services. It's a 1-hour course. And they've submitted it for employee training, continuing qualifying ed. I think we can safely say it's probably 1 hour of continuing ed.
Continuing
if you
ed.
guys
Continuing
felt
ed.
like it even had that much information.
Yep, I want
Continue
to,
that.
Madam Chairman, I make a motion we accept the LSS Introduction to Passive Fire Alarm Protection and Code Requirements for 1 hour of continuing education only.
I'll second that.
Motion by Mr. Roberts, a second by Ms. Jones to approve this course. 1 hour for continuing education only. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
The only thing we have left are all the ADT courses.
Well, no, we have an ADT secure or safety and basic electronics that did have sufficient, but
They
if Mr.
did.
Tucker can vouch for the others, do you want to lump
It's really
ADT?
up to you guys. All these courses were previously approved by the board. They have
Right.
expired. They were approved in '05. They should have been resubmitted in like '09 or weren't. but they have resubmitted those. If you feel comfortable with the ones that I had marked insufficient info based on Ken's comments.
For
because he
continuing
really-
education, they will be great.
Well, Gary agreed to send everything
Motion
so
to
y'all
take
can
this.
review it in March. I don't think these are that urgent. It's mainly for
Space
their,
cadets.
they don't offer them to anybody
Space
that doesn't
cadet
work for them, so.
Oh, yeah,
Beth,
area.
the
Pretty
ADT
range.
course on basic electronics, they were requesting 8 hours of continuing education in Berg, Fire, and CCTV. There was material presented there that I felt like that we could reasonably accept that. Yes, 8 hours of continuing education. It was a pretty decent course. That was the ADT Basic Electronics. So I'd make a motion that we accept that course for 8 hours continuing education, Berg Fire, closed circuit television.
Second.
Okay. We have a motion by Mr. Roberts, a second by Ms. Jones to approve the is it basic electronics? I believe,
Basic electronics, yes.
for 8 hours of continuing education in all categories, fire, Berg, CCTV. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
What about the safety course that we're?
Yeah, I just, there weren't any materials with the other courses, and so I just didn't feel like that we, now, if Steve's got experience with the courses and feels comfortable with them, I would certainly consider his recommendation, but based on the materials that, that was presented to me,
I gotta be honest, I taught that safety course. You're saying 4 hours?
Maybe 1 hour.
No, it's really about, it's a lot to do with ladders, I'll be honest with you. They were losing so much money. We had to bring them in, let them climb a ladder.
So it wasn't devices or nothing?
No, it was serious safety. I probably would give 2 hours for that course, but it's in the basic part of what they do on a regular basis. It's not taught by itself.
Again, if you want to hold off till Mr. Kelly can submit the materials and review all these in March.
Maybe they added drills and hammers to that.
Well, actually, you
got a
have the
drill,
information on safety
not-
because you just approved it for Mr.
Yeah.
Creasy's.
That's correct.
continuing
It was
ed.
included in that previous.
there was a little bit of information there.
I'm gonna say that's a pretty extensive course, but it's just a part of what they do. I would give 2 hours for it.
And not 4.
Yeah, because they would make them come out of the field for 2 hours. I specifically remember that they wouldn't go 4. They didn't want to lose productivity.
All right, you want to make a motion that we approve for that for 2 hours continuing education?
Yes, I'd like to make a motion that we approve that for 2 hours only.
That's the ADT
ADT
LLC safety
LLC
class.
safety class.
Okay. We have-
Second.
We have a motion by Mr. Tucker, a second by Mr. Roberts to approve this safety class by ADT for 2 hours of continuing education. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
All right, the rest of these, he only submitted just a one-page outline on these courses and
We have any new business before the board today? Any old business?
I have one question. It won't take y'all long. This goes back to a rule in the law books, and I've searched and searched. There was a fella told me that he did not want to run his vans with the name and certificate number on them because he didn't want people to know it was a company and try to take advantage of and say, oh, here's a nice company, they got a lot of money, I'll just lock up in front of them, let them hit me in the behind end or whatever. But are you not mandated to have your registration number on all service vehicles?
You have to.
Yeah.
law.
We are talking alarm contractor.
It's in the law.
Yeah, it's in the law.
And he told me to read my little book. We got an argument about this. He said, if you don't put your company name on that truck, you don't have to put your company certification number on that truck.
There's nothing in the law. It says you have to do business under the name under which you're licensed, but it doesn't. There is a minimum. I think there's one thing in there that says you have to identify, but say you've got people out working in their private vehicles.
No, they're company vehicles.
I understand that, but.
Well, don't we find people every day for not having the number?
Yes.
Yeah, but
That's
if
what I
it's
said.
identified as an alarm.
If it's identified as ABC Alarm Company, but if you don't have your name on your truck, he says that the law doesn't specifically state you have to have your certificate number on your truck. So therefore, he runs his company vehicles without names.
I think he's
I would believe that's a correct interpretation. The idea was to prevent someone from advertising themselves as a security alarm company, with lettering and
Without
sign
being
on the truck
certified.
without being
But
licensed.
now they're in people's yards with no name, no identification at all, and making other neighbors suspicious. That's how I found out about it. I was called. Actually, police
could
chief
put-
called me.
If he put a sign on the side of his truck saying Joe's Pool Hall, he doesn't have to have Tennessee license number such and such.
Well, they're not mandated to be licensed. They're just supposed to be open all night. I'm saying if you have an alarm van, you
Okay,
gotta
well, here's
have.
the law right here. And I know at one point last year when you were discussing these rules, you were actually considering prohibiting people from using magnetic signs. I think some of these proposed
Well, when you
rules-
read that, it says all alarm systems contractors shall permanently display their certification number on all advertising
Service
service
vehicles.
vehicles, but it doesn't say anything up
It's
there
a service
about.
It
vehicle.
doesn't say you have to
That's
have the name of
common.
your company on your service vehicle.
But it,
That's right, you just have to have the certification number.
but he don't want to run his certification. He doesn't want to run the name to keep from running. He doesn't want to run the name, but he still is required to run a certificate number, correct? Even though he didn't put ABC Company.
Yeah, but how would we know if there's no name
You're
on
going to
the
know I'm
van?
going to turn him in. Because I'm going to win this
Again,
argument.
I mean, does he
overall.
have, I mean, y'all don't have any regulations at all, and these are what you have. It says you gotta do name under the.
I know, but when he just made that remark, get your little red book out. He said it does not say that you have to have your certificate number on there if you don't have your name on there. But that don't say if you don't have your name. It just says service vehicles.
We have had instances where alarm companies were installing a system or equipment where they did not want to be recognized there. And
Correct, he doesn't. But the law says he does. He has to have his certificate number on there, whether he has his name as his company on there or not.
that's what it says.
I mean, it's just going to be $100 lesson for him, times however many vehicles. But
Somebody have to take a picture.
I mean, how you gonna?
I tried to help him. I said, "You're wrong."
Why don't you
If
take a
he's
picture
got-
of his truck?
I mean, are you gonna? Does he have a shirt that says the name of his company and he's getting out of a white van? How are we gonna prove that?
Prove what?
Right here.
And running a company plate on it instead of a individual plate. Running a so many 1,000-pound plate on it. Business plate. That means it's a service vehicle.
Well,
And if the plate is registered to the company, then the company has to have the certificate number on it. What I thought. Okay, I'm done.
Take a picture and send it in.
of it, and it's gonna be a white van that has nothing on
With his
it.
tag number.
The tag number, the tag number's gonna be
Right.
registered to the
And then-
business.
Then he would have an issue with it.
And then you're gonna say,
The only business he operates?
And then you have a gentleman
He
or a
doesn't
lady
have a
step
vacuum
out
cleaner
Nope.
repair service or some other business.
in a uniform and,
negatory.
okay.
If he hadn't
Anybody
smarted
else
off
have
to me, I
anything?
wouldn't have
That is
pushed the
it.
Anybody
issue.
else have anything?
Probably have a hard time claiming it wasn't a service vehicle.
Well, if it's got a company tag on it.
All minds clear? This meeting is adjourned.
Oh,
Quack.
wow.